For delivery of orders, item number 2, WPC 23548 of 2021 with WPC 20890 of 2023.
Over 2 meters, they have said that it is similar to Panchayat. The process.
Which matter the police has? Yes.
The matter was they have not paid for yesterday. In view of the urgency, not fitting it at 3, you have to post the matter today to give it to the other side. But then I today, but confine my submission to violation of 3 essential conditions in this process. Only 3 non-essential conditions have been not complied with by the private OP number 6. That I'll confine it to today only for the purpose of my intent. But my first contention is
I have received the copy daily for yesterday, my lord, and I am filing my preliminary counter affidavit by giving the documents, my lord, which I am submitting to my non.
Preliminary counter affidavit means?
Because in short period I could not able to gather all the
That is
documents.
not the way. That is not the way. Either you raise a preliminary objection, which must be purely a question of law relating to maintainability, relating to exercise of the jurisdiction. But if it is a factual aspect, then we'll have to decide it on the basis.
Yes, but there is some documents I have given.
So that is a factual one.
Yes, factual as well as the yes, my lord.
No, it's a factual one. Yes. Give it, we can't.
But you actually take up WPC 879 of 26.
You are appearing for appeal for number 6. My name is wrongly dictated, but my name. Mr. Mishra, are you appearing for civil supply?
Instruction to appeal for 2, but I have not yet received the instructing house brief, and the instructing house is to file the power also. I came to know yesterday evening.
Therefore, immediately copy was submitted. Now,
The copy has been given to us.
File is tender committee Orissa civil supply committee.
No, OP2, the civil supply.
OP2 is there.
Tender committee will be state. Maybe the district manager will appear. Tender committee will be state because it is headed by collector.
Collector is there.
Is it not a tender committee of a civil supply corporation?
True, it is, my lord, but the state will be there.
What? Maybe one of the member of the tender committee is the nominated person of the state. That does not mean that it becomes a state.
No, my lord, it has been delegated to them to decide so far the tender matters. The policy decisions is being taken by the corporation, namely the terms and conditions of the tender and all those things. But I'll assist your lordship provided I have.
It is a state who constitute a tender committee, or it is a corporation who constitute a tender?
It is a corporation who has constituted.
So,
I'm not saying that, but it has.
no, sir, I just wanted to understand this proposition of law. Let me understand.
My lord, in fact, we will assist together. That is there. That much I can say.
That means that you should represent him also. Committee.
As far as the tender committee is concerned, usually the state appears.
No, sir, why? Why?
And then the collector has to specially engage because
So,
capacity.
I understand that, your lordship. The capacity of the tender committee.
this is something very unique, I find. Very unique things which is prevalent here.
I don't have a copy yet, so I can assist better. I have a copy.
Administration.
What is your...
My point, if your lordship permits me, I will place my 3 points. Now your lordship may see. First, your lordship may kindly turn to page 30 and 69 of my paper.
Page?
Page 30 and 16. So this is a tender. Before that, your lordship will kindly see clause 22. I'm sorry, your lordship will kindly see page 22, the mandatory clause. Non-furnishing of any document will lead to rejection of the tender. That is, your lordship will find page 22, it was 1.9. Page 22 plus 1.9. In the middle part of this page, page 22.
So this is really a verification or production of the original documents.
This is the clause in the tender
That's all.
paper. Tender paper not accompanied with all the schedules annexures.
No, page 22, 1.5,
Page 22, 1.9.
9. Okay.
I'm sorry, 1.9. Tender paper not accompanied with all the schedules, annexure documents as detailed at check.
Anyhow,
But this
the
is
mandatory condition,
mandatory.
consequences is provided.
That's
Yes,
why
that
I wanted to show that. But now your option may see page 30.
page
Page 30.
30.
30. Last but one clause of this clause.
Yes.
The bidder shall furnish certificate from any national scheduled bank indicating his or her financial capacity for an amount of not less than rupees 25 lakhs. The bidder is to furnish financial capability certificate issued not prior to 3 months from publication of tender as per sample format enclosed annexure 3. That your lordship will find at page 69. Sample format is page 69. Page 69.
Yes.
The top clause, clause 6.
Yes.
Director of the bidder attach certified copy of statement of account for last 3 months.
What? Attach certified
Attach
copy of the
certificate.
statement of account for the last 3 months.
3 months. Yes, sir. That
True.
clause I read. But this are, if your lordship see, the lordship will see, kindly see page 252. That is the statement which the bidder has filed.
Yes.
252.
Yes.
Lordship will find that this is not a certified state. So this is violation of one of the mandatory clauses in the term. This is not a certified statement. This is the document he has filed along with the creditor. Last 3 months bank statement, which is not certified.
Uh,
Like, if I come to the next point.
Under the Bankers Book Evidence Act, what is required?
The Bankers Book Evidence Act, that is for the purpose of a civil suit and
No. It is not restricted to. We are deciding a writ petition on the basis of an affidavit evidence. We are treated as evidence. Then
From my lord.
nowadays, if they say that you download this information from the official website and it is an auto-generated document,
Right.
does it require certification now?
Well, certification is required in view of the tender condition, tender clause, whether you are.
Those are the archaic
Correct.
principles, archaic rules prior to that particular.
Look at the judgment I'll be citing for that.
Anyhow,
I'll be citing a judgment for your lordship to interpret and consider it, because any condition in the tender.
now we have to understand in the perspective of a technology as
So
well.
your lordship, I understand it, but then kindly see this judgment below. The words used in the tender notice are to be simply,
No, I understand.
kindly see that judgment.
Correct.
I will do single judgment. Kindly see this judgment. I'll cite this, your lordship will consider that. Kindly turn to page 63 of my copy. Well, I'll be going again other two conditions which your lordship may interpret, but then before that I must cite this judgment.
Hey, where is the Bankers Book Evidence Act?
But kindly see this judgment. Page 63 of my compare. Right, Milord.
Second match.
Milord, that is the certified copy again, sir. For your lordship, may see Bankers Book Evidence Act. Kindly see, Milord, that section here, your lordship is referring to section 4 of the Bankers Books Evidence Act. Kindly see that. Please, boy, this says mode of proof of entries in the Bankers Books. Am I? Have you lordship? Let me read it, Milord. To provisions of this act, the certified copy of any entry in the Bankers Books shall be in legal proceedings be received prior to the evidence of the exercise of such a certified copy. So that is what is said in the.
This was decided when?
Which one?
When is there any corresponding amendment having brought in this act itself?
No, but this is the original act. This is the provision. There is no other provision.
Oh, I understand. I am aware of the provisions. I'm just talking about now by virtue of the technology having advanced under the Evidence Act, 65A, 65B has been introduced. I just wanted to know whether the corresponding the amendment have been brought or not.
No, no.
Relating to electronic documents.
But he is very.
I'm
he will be
I'm thinking of that.
Yes, he will be
Electronic document.
We will be verifying it, come back to your lordship. Kindly see, Lord, page 63, or your lordship is looking at the act itself.
Two A has been introduced in 2000.
Right.
Obviously, after Information and Technology Act has come,
Coming, right.
Section 2A has been introduced, the printout one. This has come, brother.
I think we will not be governing it.
Or
I don't, they let me verify.
what are you talking about? No,
Verified.
it has to. It says that a printout of an entry or a copy of a
I am
printout.
asking my lord's registry to also help me out, since your lordship is holding a copy.
Eh,
Even now, we allow website, web portal.
India Post.
Copy of order.
India Post.
No,
That's fine.
Even India Post
India Post.
showing that the service has
Tracking.
been
Tracking report.
yes.
Tracking the High Court orders.
No, I understand.
Your lordship, see, this also has not been complied with. That's not there. But, my lord, I cannot.
That is only because of 65A.
Yes, yes.
It says that you'll have to make a declaration or certification that you have downloaded it from the official
that's
and
it.
everything has to be done.
That's even not there. But I salute my lord to my lord's query. That is also not there. Going to that extent also, it's not there. Now we are coming back to page 63. Certificate is not there. Coming back to 63 now. Para 14 and 15. I think I can persuade my lords on this.
60.
My compilation page 63 para 14 and 15. We must reiterate the words of caution that this court had stated right from the time when Ramanadaram City versus Interest also was decided almost 40 years ago, namely that the words used in the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. In this context, the use of the word metro in clause 4.2a in section Roman 3 of the bid documents and its connotation in ordinary parlance cannot be overlooked. Para 15, we may add that the owner or employer of a project having authored the tender document is the best person to understand and appreciate its requirements and interpret its documents. The constitutional courts must defer to this understanding and appreciation of the tender documents unless there is a malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. It is possible that the owner or employer of the project may give an interpretation to the tender document that is not acceptable to the constitutional courts, but that by itself is not a reason for not interfering with the interpretation. But keeping this certain position in view, now I'll try to carry my lords with the tender condition and try to convince my lord how flagrant violation of the essential term of the tender, not only in this clause, other conditions also I'll take my lord. First, I have been, at least I am trying to show that even backwards books of evidence act and certificate is not there. Now, second is it's not a certified document, which not simply it's not a certificate, whether it's a printout or it can be dispensed with, or if it can be dispensed with, that must be dispensed with uniformly. That must form part of the tender condition. That in case of a printout, every tender also should know this. So it is not in an unilateral in singular case that it can be dispensed with, whereas other tenderers have taken the pain of certifying it and producing it. So it must be uniform. Any relaxation, Air India Authority in similar case, any relaxation, LIC case, must be uniformly applied. That must, any power, additionally, any power of relaxation should be there in the tender notice itself. So that should be uniformly applied. In my humble submission to your lordship queries, but if any kind of relaxation is given to this, then that should be brought in the tender condition itself. Unless that is there, the other tenderers will take the will be discriminated. Now your lordship will see the second non-compliance that I was submitting GPS enabled VLTD. GPS enabled VLTD, lordship will kindly turn to clause 4.12, page 32. Kindly turn to. I was impressing upon your lordship on last day. Your lordship was insisting for some clarification on this. Kindly see page 32. The bidder shall have minimum 2 number of transport vehicles installed with GPS enabled vehicle location tracking device (VLTD) registered in his or her name. The heavy vehicle like the tipper shall not be considered as a vehicle carrying food grains for the purpose of this tender. Refer to clause 8. Now your lordship may kindly turn to again clause 8, my lord. That is at page 36. The bidder, page 36. The bidder shall have minimum 2 number of transport vehicles installed with GPS enabled vehicle location tracking device registered in his or her name. Additional requirement of vehicles installed with GPS enabled vehicle location tracking device can be availed on higher basis. Now you will may see that this registration and the VLTD certification is to be obtained from the approved dealers, approved authorities, that says in the tender notice itself. That is page 59. Para W. As mandated by Government of India, so, and any other notification by Government of India or Government of Odisha from time to time, the VLTD is to be installed by GPS tagging of all vehicles used for transport of food grains in the public distribution system. Accordingly, transporters are required to install and maintain with vehicle location tracking device in the vehicles at their own cost. The details of empaneled agencies / vendors appointed for this purpose are available in the Transport Department website. That is so and so and so. The VLTD must be procured in accordance with norms prescribed by State Transport Department and shall be installed in compliance with the specifications and standards available in the above website. The contractor should have sufficient VLTD on hand as backup to be utilized for additional vehicles or in the event of technical problems arising in the already installed VLTD and the used vehicle. It will be the responsibility of the contractor to check the functionality of each VLTD prior to installation in transport vehicles for transporters of food grains. What is the importance of VLTD? They are transporting food grains. Today, food grain, after being loaded from one location, there are innumerable examples that diverting it, black marketing, unloading somewhere else, and thereafter the whole government stock is being disaffected. That is the reason this GPS enabled VLTD, they have made it mandatory. Now, what have you given over here? Kindly turn to page 265. What have you given in contract to this one? 265. Now, this they have given a letter to the registering authority, Transport Department, Bhadrakatyo, from an agency. Kindly see, madam. And what does it say? That endorsement of VLTD serial number in the vehicle registration number shown. Now they say that this VLTD is fitted with this vehicle. Now who has said it? Vikas agency. Now whether this is one of the empaneled agency in that, as I have read, that is not true. Subject to
That is not there as well.
that's there.
They have said that you should comply with those agencies who are registered with the official. You have not produced any document that he this agency is not
But I
registered there.
subject to that query of your lordship is genuine, my lord. The supply corporation can clarify that.
Why a reverse presumption, the onus,
Why is
why the reverse onus?
yes, Lord.
Onus is on you to prove first.
Yes, Lord.
First you discharge your initial onus
Right,
and then it will shift upon him.
Yes, Lord. When I accept it, God on before my
So-
lord. Yes, Lord. My lord will say, my VLTD registration certificate which I have given, which is issued by the competent agency, that is at page 127. This should be like this. Kindly see 127. This is a letter, not a certification. Kindly see page 127, my lord. This is the kind of thing is required. VLTD device number so and so accessory comes to this customer certificate. There is a barcode available here, and entire data and particulars are available here in this certificate. This is the kind of certificate issued by the approved agency.
Where is the signature of RFC?
Kindly see name of the SIM provider is there, BSNL, Airtel.
Right hand side bottom, same page,
Signature of RFC. No,
Where
it's
is-
downloaded copy. It will not be here.
same principles.
No,
You are talking about that bank statement,
That is there with the original tender paper. If they say this, then I can counteract this. That is there. But it cannot be said, they cannot say that this is not a certificate.
That is what I was saying, when you are arguing for the certification, that's why I say the
This
same.
is
same principles applies
there
here.
with the original record. Look, this is the downloaded copy, which we have downloaded from the website. This will not have.
Sir,
That is there in the original
copies-
record.
You admit that downloaded copies need not be signed.
No. Not here.
Sir, no.
That is there with the tender paper, tender authority. That is there. That your lordship can verify from there. This certification, your lordship, see what they have said, whether this is a certificate, this is a letter. Kindly see that too by one Vikas agency. Whether this is approved or unapproved as per that tender condition for your lordship to consider, my lord. It's for me to raise this point. Now my third point. Now coming to the third deviation, my lord. Kindly see that proprietorship issue which your lordship said that, yes, my lord, in legal parlance, I can accept the defeat from my lordship, that I can. But not on the question of the lordship says, the tender specifically says, clause 8.3, if you are giving a registration of a vehicle in respect of a proprietorship firm, but that vehicle should be registered in the name of the vehicle. That is what their clause, the peculiarity in the tender notice. I am not a person to correct that, nor I am a person to override that. If your lordship is looking at that judgment, the meaning of the tender condition.
They knows, but then if they have accepted it as a compliance, then can we go into that
So
aspect?
there also my same reply to your lordship.
Because you, that judgment you are relying at page 65, that says that the authority who issued a tender document is the best person to interpret the terms and conditions of the contract.
Not there.
Tender. They are the last word, even if the court has a different view on a logical basis, that will not invite an interference. Your own judgment you are citing.
That case, that must be uniformly applied. That is what my point.
So it is also,
So they cannot say.
and you know, under the legal parlance, a proprietorship concern is nothing but actually a concern where the single person is running the business.
Yes.
What is the concept of a proprietorship or a partnership is
Yes.
that one person, single or more than one person, they jointly or singularly, they are running a business in a compendium name. And the compendium name comes either and company or whatever. These are all the compendium names.
I think there is no confusion between your lordship and my conviction over there. Lord, remaining.
You are saying that if he is running a business
Lord, I am not saying that.
as a proprietor,
I am not saying that.
as a proprietor in the name of Messrs. X and Company, then the vehicle must be registered, should not be registered in the name of X and Company. It should be registered in the name of ABC.
My lords,
If I understood your argument.
My lords, coming from the both common civil background, both your lordship and me, and my lords also, but there is no gap between your lordship's mind and my understanding that proprietorship and individual are one and same. There is absolutely no amount of doubt in my mind or in your lordship's mind. But I don't say what your lordship said. I don't say what your lordship said. What I say is the tendering authority being conscious of this position of law, if have expressly placed a condition in the tender, irrespective of proprietorship for owning a truck, the registration should be in the name of the individual. But then I am helpless. I'll have to go by their tender itself.
Is I would say unconsignable provisions.
Yes, 23.
And it talks about the perversity also.
Your lordship can declare it as void.
Your judgment says perversity is one of the
Your
grounds.
lordship can declare it as void, being contrary
It's
to
a
public
perverse,
policy.
not void. It can't be a void. It has a purpose.
Yes.
And the purpose is to be achieved. The
Yes.
purpose is
Yes.
that it should not be in third party's name. Ownership has to be established because one of the clauses, the two vehicles must be owned by the intending bidder. Two, he can put it on a higher basis or a more. Now, once we talk about the ownership concept, then how the ownership concept is to be carried forward. We have to go by those lines. Perverse.
To that,
If you want to achieve the purpose, that's
that
all.
my reply would be, my lord. To that my reply would be, it's a kind of reading the tender in a particular manner or giving relaxation.
No,
in relation to the condition.
I am telling you, Mr. Roth, had the authorities took a decision or taken a decision giving this a stricter meaning, what you are suggesting,
Yes.
then there was also a very little scope for the court to interfere. Even if the court thinks that the law is otherwise, that is, I am bound by that observations of this judgment.
But before that.
If they have interpreted
Yes.
in a more pragmatic manner
Yes.
or in a beneficial way,
Right, my lord.
how can a court substitute its finding,
And I leave it to my lord.
taking a very stricter view of it?
My lords, I leave it to my lords, looking at their records, if they have relaxed it or they.
It is not a relaxation. It is a question of
Whatever way.
perseverance. It is a question of interpretation.
If they have purposefully or for a homogeneous reading of the clause or for a purposive interpretation of the clause, they have read it that yes, proprietorship part, which we have said in clause 8.3, can also be in the name of the individual or may not be in the name of the individual. That material has to be produced before mine. Otherwise, I will have to go by the tender condition because you have to be uniform from everyone. I would have given document of the proprietorship part. Then why did I give a document in my name? So I say you are not uniform then. Article 14.
No.
Yes, kindly see that clause.
It is-
Why then you have?
So they must have applied in that, and they have taken a very pragmatic view in this regard. Whoever owns the truck in the name of the proprietorship concern or in the name of a proprietor, they have accepted it as a sufficient compliance thereof.
Kindly see clause
That's all.
8. Let us read it together.
Yes, they have said even if it is a proprietorship concern, it should stand in the name of the proprietor.
They have made it more forceful by subsequent lines. Kindly see.
What?
Kindly see.
What?
Lord, I can kindly see this. In case of sole proprietorship, the vehicles must be registered in the name of the bidder. Then, in case of partnership farm, the vehicles must have been registered in the name of the farm or any of the partners. An affidavit of the partner who is registered owner of the vehicle has to be furnished about use of such vehicles by the farm for transportation of operations of the corporation without any objection. In case of company, vehicles must have been registered in the name of the company or in the name of the director.
That is what it says.
They very well understand the legal.
No, the difficulty, I tell you, when you talk about it, the company does not mean that the directors are owning the company.
Certainly not. It's
The
only
directors are a different concept.
Certainly not.
They may be in charge of the running of, managing, administering, running the company for the profit. That is one thing. They may not necessarily be also a shareholder of the company. There may be a nominated directors. There may be a co-opted directors.
Taking decision.
I'm saying that. So he says the director, either in the name of the company or the director. When you talk about it, then the intention is something that is bidder may be a company, the bidder may be an individual.
No,
If is a company who is bidding, then if it is owned by a company or if it is in the name of the director, no issues.
all that I can say.
So similarly, proprietorship and very interesting words are used that shows that they are not really aware.
My lords, let them, that is in fact.
They say the sole proprietorship for
Yes.
or concern. Can there be a proprietorship of more than 1 or 2%?
They are the best person to answer your.
Can't be.
They are the best person to answer your.
So it's a sole, it's a one person who is a proprietor
Go by the.
or a proprietress, whatever.
Lord, I will go by that tender condition. Lord, if at all they have done it pragmatically, then they should do it
Anyhow.
pragmatically for every bidder.
VLTD
But now-
concept and everything, three concepts you have raised. One is the, may I jot down? May I jot down? First thing is, they have not given a certified bank statement. They have not given a certificate concerning the VLTD. Third one is that they have not produced any document showing that it is the vehicle is in the name of a proprietor.
Bidder.
Bidder. That's why I was coming again. Now, the word bidder is used. The bidder may be a proprietorship concern or may be a proprietor himself.
For them to explain me, Lord. Now, Lord, your Lordship will allow me to fourth one. Lordship will allow me to raise my fourth point. I have,
You said three
Lord, I
at the
have-
start.
But subsequently it struck to my mind, there is a fourth one. There is. Lordship will allow me that one. A very small, Lord, 1 minute time. Only one. I'll not go for a fifth one. Fourth one. kindly permit me. One, maybe I may.
Yes.
Pace pretty.
What?
Lord, it is again very essential condition. One of a tender condition which is required, tender document which is required to be signed and submit. Kindly see Lord, page 29. Lord, I do not know what is the object behind this, but they have put it in that tender. The bidder at the top of this page 29.
Duly signed.
Yes.
Copy of the corrigendum and addendum along with it.
Yes. Now there is a
If there is.
yes, there is a corrigendum along with the tender notice, which should have been submitted by the bidder duly signed, and he has submitted it without signature.
Where is the corrigendum?
Yes. Page 96, my lord.
Yes. No, this is a corrigendum.
Yes, this is. You will have to submit it by signing over here. Kindly see, Lord. Yes or no. That is why the signature is required. Read that, no? Read that, Amol.
No, this is for appointment.
Lord, this is my document. He has not even submitted this document. This is my allotment. I have submitted it by signing over here.
But not saying yes or no.
Lord, he has not even submitted this document. This document is my document. I am showing a sample to your lordship, ma'am.
What
He
is
has
the
not
meaning
even-
of that? Yes may be read as no. What is the meaning of
Maybe, but he'll have to submit it.
Oof.
He has not submitted it, ma'am.
If there is no discrepancy, there is nothing. Then
This document has to be signed and submitted at least. He has not submitted it. That's the point. Yes or no, maybe either way, as your lordship will suggest. But he has not submitted this document. Either way, Lord. My Lord, I catch a very, I have to, my Lord, to interpret and come back, Lord, whatever. But then he should have submitted it. That's all.
I have submitted a small plan minor, in which I have stated that I have submitted all the documents along with the tender. And the last is test there, the minutes of the tender committee and the technical evaluation. And that has been there, the RTO is a party to the tender committee. And he has verified all the documents of the vehicles as well as the realties. And thereafter it has been allowed, which has been mentioned in the test 17-year lordship in case of mine. Because the petitioner has submitted his tender in respect of 6 units and he became disqualified in the price bid after opening of the price
Not
bid.
disqualified, he is not
Not
successful.
successful after opening of
Maybe.
the price bid because he has quoted in each unit.
Whatever higher price than,
Yes, yes,
than you, whatever.
In 17-year lordship,
Yes.
everything has been in respect of
Who are you, serial number?
Biraj Kumar Bhuya, serial number 3.
3, okay.
One I am showing, my lord. The active holder present in the meeting checked the validity, authenticity of the documents relating to owned vehicle of the name and Biraj Bhuya mobile name.
From where you're reading?
My lord, middle person, the active. I am reading entire matter. On
Yes.
scrutiny of documents, certificates and affidavits are required under checklist appendix 2 of the tender document. The DLTC found that Sri Bhuya has uploaded all the required documents as per appendix 2. The RTO Bhadrap present in the meeting checked the validity or authenticity of the documents relating to 2 owned vehicles of the name of the Bhuya from mobile app. The bidder Bhuya present in the meeting all produced all original documents for verification by the DLTC. On thorough scrutiny, verification of the all documents, certificate and affidavits uploaded by the bidder, the DLTC being satisfied with themselves unanimously decided to accept the bid of Sri Bhuya in technical bid evaluation. Thus, the Biraj Kumar Bhuya has been qualified in technical bid evaluation for the Dhamnagar block and 3 GPs of HON'BLE block. Similarly, page 16, my name is there, serial number 3, my lord. The petitioner is above me.
The same thing is about him also.
Yes, ma'am.
Serial number
Same
2.
thing about him. Thereafter, the price bid is opened on 6th, my lord. Next, annexer B by 6 I have given, my lord. And in between, my lord, this proceeding has been drawn after taking into consideration the objection raised by the petitioner as well as me, my lord, in respect of the deficiency in both the tender. His tender as well as my tender he has shown that has been taken into consideration by the end.
Where?
And I have stated in my affidavit, my lord, that documents has been sent by the CSO to the committee, my lord. Your lordship, thereafter the price bid is opened, and since I have quoted the lowest price in respect of bond block, only I have been selected in respect of bond block.
Yes.
And now the other persons are selected in respect of Bhandari Pokari and other blocks, my lord. Those who are not party to the proceeding also. Thereafter, the order of appointment has been issued on 12/1/2026 and the agreement has been signed. Your lordship,
I take permission to interrupt now. I may non-suit myself. One second. If I have, 1 second, Mr. Vishwal. I may non-suit myself if you are saying that. Kindly appreciate, Mr. Vishwal. If you are saying this is a challenge with regard to Bhandari Pokari block. If you are saying that you have not been selected for Bhandari Pokari block, then what is the point for me to challenge your? This is for Bhandari Pokari. 1 second. I may.
He's correcting himself.
Yes.
What is there to fight against me?
No.
You have to be fair with everyone. But,
No.
so Bhandari Pokari I am challenging. If you are admitting that you have not been selected for Bhandari Pokari, I think my challenge doesn't remain anymore. I think
True. So you have improperly made him a party because he is not a selected or
that's the
successful.
development after the filing of the petition.
No, man, it is
26.
No, this is 6-1.
Your lordship see the affidavit shown on 4/1.
And
The
read
document
was filed on
submitted
6/1.
annexure 1 which has been uploaded on 5/1, man.
That's different matter, but then
No. This the financial bid was open on 6/1.
Yes, man.
it was filed on 6/1.
Your lordship, you see the affidavit.
So
it has been
you
shown on
are not a
4/1.
successful bidder.
Yes.
So far as the Bhandari Pokhari block is
No,
concerned.
he is not.
I am not.
That is
I am
what
on
he's
the
saying.
No, this document also speaks of that.
Yes.
Page 19,
Page 90.
serial number 5.
One.
It is a Utkal road carriers who have got,
Not the, you know.
not.
So,
Even
that's
last.
what I'm saying. I mean, myself. Why?
Final
why
order
do-
also
why-
is in last page. Last page.
No, that is clear.
That is clear.
If such a statement of my learned friend is correct,
I know.
if this document is correct,
So he's only in a bond block.
Yes.
and both is not under challenge for my.
Yes.
So why should we again join issues failure?
So now we have to dismiss the suit.
This document and dispose of the matter saying that there is no cause of action.
There's definitely.
Obviously, Lord, I'll have to intervene in between. That is why I intervene. It's my duty.
That's true.
It's my duty
This
to
is-
address your lordship on this.
So now everything is rest. So why you were interrupting him?
No, my lord.
He was for your rescue.
No, my lord, I don't know what my lord and senior.
No, he was, so permit him to speak.
My lord, because
You were preventing him to speak.
it has been taught to us that when senior is arguing, we should not say anything else.
No, he was
Well,
saying
my
that,
part is
that
that-
my submission will not suit my client.
Like, my lord.
So that is what he says.
I want to show the documents so
Can I,
don't know.
Can I request? Keeping this in view, let me have a word with my instructing counsel about this document. It is only served today on my pen. So
No, we will not go into this document. We will definitely go into this aspect and the entire cause of action which is needed in your.
that's kind instruct.
You are challenging that particular Bhandari, Pokhari, whatever the block.
Right.
And you are challenging that their documents are not in conformity.
Yes, and they have. not
And then
been
this
selected.
document, we'll say the document would reveal that they were not awarded a contract
Yes.
in respect thereof. So the entire cause of action which hovers around this
It's gone.
is gone. So it has,
This leads
so what is clarification?
Tomorrow, for this.
What clarification?
I think this is a downloaded copy. I'll just tell your lordship that it is not there.
These are the authenticated copy. Nobody can deny, and this is on affidavit. This is on affidavit.
Second case. Okay, sir. Your first case is not there. Now I'll come back to the second. It is, as your lordship rightly, it may dispose it of with that observation.
Second one is,
That is Utkal is a party.
There is a party.
Utkal is represented by,
Appearing for the opinion.
okay. The same point,
No, little different. Lordship may dispose of this matter, then I'll come back to it. I am sorry, Lord, I took so much of time. If my learned friend would have said this in the beginning, then I would have said that there is no problem.
this matter is,
No, you never said that you are not sorry.
sorry.
Yes, sir. I have told my.
The instant writ petition Yes, call the next.
Next one, I think, by amendment appearing for Utkal, the same block, Mandarpuri.
Bandarpokari.
Yes, same block. The selected one, we are challenging, that Utkal carriers were challenging.
Where is the Utkal? Same ground or a different ground?
Essentially two grounds, one ground common, VLTD, other is this, the document, there is a clause in the tender, page number 25, 24 and 25, that the tender paper is to be digitally signed. Kindly see page 24, 25. OTC. Roman 13 month.
Yes.
The bidder shall digitally sign on all statements, documents, and certificates uploaded by him, owning responsibility for their correctness, authenticity as per IT Act 2000. If any of the information published by the bidder is found to be false, fabricated, bogus, invalid, corporation shall have the right to disqualify him
So
or
that
her.
is what is, if it appears to be false.
Right. They have the right to reject it, but digital signature should be there.
Yes, then they have not submitted.
Then below, next page, Roman 15. Fourth from the bottom.
Mhm.
The bidder has to digitally sign and upload the required bid documents one by one, as indicated with tender document, along with letter of proposal and tender submission undertaking as per format given in Annexure 1. But my contention is he has not digitally signed the tender. No, he has not signed. The second is that GLTD.
Here the petitioner is before the lordship that due to non-filing and taking of decision on contract closure proposal, the petitioner is deprived to get his final amount, which is pending with the authorities since 2020. On the last, they have to seek time.
My lord, sir, valuation of the work done by the petitioner amount to rupees 84,67,889, and this less deviation has also been willingly accepted by the petitioner. Out of this amount, my lord, he has been paid 82,67,000.
Whatever, certain amounts is still due and payable to him.
Because
As far as my instruction in the meantime, within 2 days, so far as the facts and figure my learned friend is saying, so far as getting of the amount and outstanding is completely differ from my books of accounts, the lordships.
What is there?
My lord, so far as the work order, the lordship will see the.
Then, brother, let us permit him to go and sit together
Yes, sir.
personally, and then this payment. I will be happy. I will be happy if in all the matters the state says time limit. If they adhere the time limit, I think that 80% of the litigations would be reduced. Why the court will pass a direction? It is not your duty to do everything. You could have called him much earlier. This appears that there is some dispute on the amount. Come, documents would be there, resolve the disputes. You are not denying that he is not entitled to an amount. Only thing is the quantification of an amount. So you'll have to sit together and resolve and then pay his genuine money. It's a genuine claim.
I think you have one statute, Odisha Right to Public Services Act, 2005 or 6. There is time limit fixed for each work to be the authority to comply.
Yes.
So what direction?
The petitioner had approached this court
But Sabina.
Sabina Abraham, sir.
We have interpreted that agent is agent. Legal hair is not agent and all other things we have discussed. We have prepared, we will upload it.
Lordship's item 43.
Yes.
Item 43 also, your Lordship is similar. On the last occasion, it was tagged, but somehow today it has come up in two different item numbers. So,
We'll look into the 43 and then if it comes, my brother will take care. 43 is the same thing.
on the last day, it was tagged.
Item 43.
No, we have put, let us see, let us see.
Or-
After, I find some distinction between. That is, I think, income tax matter,
No, your Lordship. This is also a service tax matter.
service tax, let us.
Why,
Item number 5.
Regarding
yes,
regarding the minor matter.
everything has been done. Instructions.
This is a peculiar fact, which I have to concede to that is that knowledge. You know, the contract was executed only for 1 year, members. But the instruction states 5 years, but the document says otherwise. Thereafter, demand has been made and the agreement has not been executed further. So, members, the subsequent demands are without.
It has to go.
Without.
Recording you are.
Yes, member.
Huh. That has to be quashed.
One more thing, subject to your the participation. If only case for example. Yes. So it's up to 31st March 2022. Consent to operate. It was around 40 some odd days. This was my instant application saying that though it was my deposit was for 1 year and because of the delay, it could not be utilized or materialized. So some sorts of adjustment order be passed. That's also instant. Within a week I have given. And thereafter, neither EC and my sister has already, brother sister has already said, those are infull because of the contract has not been executed. Not this also. Even for the from out of the 365 or whatever the tenure of around, I have only operated 45 days. And I also have stated that query, the stone is not also occurring. That so that also has to be done.
So what? That is up to your fate.
My lord, because they are, in fact, I was yesterday, what's my appeal? I was yesterday thinking, what is the process to assess the feasibility of availability of certain minerals at one place? So, interestingly, I found that the UNFC classification 2019 is being followed to assess what is the feasibility, availability of certain amount of materials. Now there G4, an entry is there. They have to assess this type of materials, whatever amount. So this has to be done prior to putting something for bid. These are not open things that someone like me who is appearing can say that is there or not. It is only after. So
That is what is the Geological Survey of India. They will have to do it. They must have ascertained that it contains some minerals. Now,
and
after that, whether you find the adequate quantity or does not find, it's all the issues that cannot be. But now the consent to operate, we can definitely say that when it was not there, it is for
Fine.
limited period, then the demand cannot be raised.
Fine.
One simple. Clear mining as that submission regarding the availability of mining time was already on record. And during the prior to the execution, there was an EC. And thereafter, for the first year, CTO had to be obtained by the applicant. It was obtained belatedly, Maharaj. And as per the.
It was not, it was applied within the time, granted belatedly. That is, the application was within time.
Yes.
That is the irony of the entire thing, which we find that the authorities are consuming a considerable period of time to give us consent to operate. Why there will be a lapse?
Other day, my lord was asking whether it is coming within that ambit of that service utility. There also, the service has to be declared or notified in terms of section 3. This has come much around 10, 12 years after. Thereafter, no subsequent notification, which are the service coming under the umbrella of that act. It's a whole confusion. Anyway, as my and speaker said, that the demands are not sustainable. My family of prayer was surrender. Yes,
Give
sir.
us a short notes.
Yes, sir.
Was.
And I will.
Short notes by Monday you give. We are
Yes.
keeping this matter on Monday to dictate.
Person could demand for termination, meeting has also, termination has already been done, Maharaj. This order is also, Maharaj.
Because I have challenged the so-called, it goes.
Then you'll have to, I mean, now the termination order have to be challenged. You just take it.
And understand.
That, in course of the hearing,
After my surrender, that is also.
oh, that is,
Yes.
please come. If the termination goes, the show cause, everything goes, demand goes, then what remain? They will take. You come with that.
Ma'am.
Is call the next.
Item number 6.
It's sir.
Today we are passing. That is hearing. Today we are passing. We have on the ground. Disposing of.
We have to respond.
Yes.
Next.
Item number 7.
If your order I have written as demand notice. I don't see what is order per the 13 this way. There was short fund involved in the resolution. No notice has been called from me, and saying that the act was ordered in past. But we put it in order.
Yes.
And also, the order dated 38/2024. The order has been passed and the delay has not been demonstrated by coming up as special law.
What long time? More than a year?
Yes, ma'am.
And what is the remedy against this order?
First appeal. See,
Where?
for the appellate authority.
Where?
Section 85, Commissioner approved.
But here, this case, my emphasis is not, I have taken.
No, again, there is one judgment which is staring at our face.
Yes. No, let's.
You'll have to convince us. When that matter is there,
Mr.
Today itself.
The matter is here.
Yes.
107, 107.
Item number.
Item number 28 here.
So let it be taken along with the 28. Just pass over.
Item number 8.
Already shown the 772.
Yes. Next.
Item number 9.
When the apex court has kept the matter? 27th of January.
Item 9.
An order challenging the particular order for non-constitutional tribunal, but I have a small prayer in addition, Your Lordship. By passing the adjudication order along with the DRC settlement is supposed to be issued along with the order, Your Lordship. There is no tax demand in my case, Your Lordship. It is only interest demand. So while they have furnished the table in the DRC settlement, Your Lordship, instead of putting it in the column under interest, Your Lordship, they have furnished it under the tax column, which is wrong. Because as per the demand, I don't have any tax demand, it is just the interest demand. So while filing of appeal, I was forced to pay 10% of the free deposit. That is first thing. Now, if Your Lordship is permitting me to file it before the tribunal, Your Lordship, again the same thing will persist and I will be forced to again pay 10%, Your Lordship.
So why did you take the matter under section 161?
So that is the wrong that has been committed by the
Ah,
council.
so
That is the rectification you could have done.
Came before me, Your Lordship, that is now, already the time for filing that had already, Your Lordship, expired. Your Lordship.
161 has also expired.
Yes, Your Lordship. It is now have come challenging the first appeal order, Your Lordship.
Appeal period is also gone.
Oh no, that the tribunal has extended.
Second,
No, six. I understood. The tribunal.
so Your Lordship.
So if ultimately they found that it is a mistake there, then definitely whatever the amount you have deposited will be refunded. They will refund.
Pay in the first place, Your Lordship. If Your Lordship just puts in one line, so that they will not force upon, I'll make the manual.
That means we are accepting the contention that it is not a tax component, it is an interest component. That is the major challenge. Oh, that's true.
The finding is, Your Lordship, it is only interest. Only in the column of, Your Lordship, I find it at page 30.
Yes, what you say, then she is correct. Then if it is only a interest component, then in that event, why? There is no question of any deposit. But they have a right to appeal. That the imposition of interest is also, they can challenge that particular exercise.
Can you show us that in the order?
Page
Give me.
32, Your Lordship. That is the sum.
Page?
32. Annexure to 32 page.
32 is DRC 07.
And Your Lordship, last column, column number 5, details of demand. So,
Yeah,
Your Lordship, turn to the next page. So, IGST 187. That is not IGST, Your Lordship, that is interest demand. Your Lordship will find from page 31, the ordering portion.
31 is the order.
Again.
It is only interest demand.
Yes, sir.
This matter relates to only.
Yes, recovery of interest. That's true. So that is. So why she should be saddled for 10%?
Then you do one thing.
Let them rectify. Wow. I understand. Oh, I understood. Can you not rectify now, suo motu? Can't. It's a mistake apparent on the face of the record.
If she filed a petition, then we can.
But now it's your mistake, sir, apparent.
I'll be then taking instructions. I'll take instructions of the
Rectify and come back.
The legal
Yes,
maxim,
07 is already-
the legal maxim is acta scuri, naninam grababit.
I'll take instruction. If it is possible, I'll be.
Whatever, it's.
Your order is for only
For
interest.
interest and penalty.
That relates to only interest, apparent. That entire order, reasoned order. Then DRC 07, you have
Inadvertently, it has been wrongly.
entry is only mistake. It is not the.
Is a ministerial error.
Hello.
So you'll have to
I'll be trying,
Definitely you should come.
keep it on the next week and you do it in the meantime, otherwise. The same thing is with.
Both the cases.
Non-constitutional tribunal.
Which one?
The.
35676?
Yes, sir. I think this.
Yes.
Item 10.
So dispose of these 35676. Okay.
Application is available to regions of the map. Which amounts to also. That is the.
BRC 7.
07. It has been erroneously, an error appears to have been corrected.
No, erroneously found as a text component within the text component.
He wants to take instructions. Mr. Tudor,
Next.
Item number 10.
Then, Your Lordship, Senior Mr. Sahu was supposed to argue the matter. He has been in an accident yesterday.
Oh, what happened?
Because during his morning walk, he fell down. So there's a calf hematoma and it's a quite big incision. So they are contemplating whether they'll go for surgery or just simply rest. He's at home, Your Lordship. So I pray that Your Lordship may take it up next week, subject to his health condition.
Next week. Accommodation on behalf of the senior advocate who is indisposed. Next week. Next one.
Item 11.
Is
The petitioner approached this honorable court challenging the arbitrary cancellation of the GST registration made order dated 21/6
you wanted a cancellation of the registration to be set aside. Come up, there is already a judgment.
who is there?
Who is there? RC cancellation. Give.
In fact, it is central GST is the party, but he has solved the copy to the state government because opposite party number one is the state government. He has made. Yes.
Assist him, give that the necessary corrections, give. Dispose of.
You are up to. Susan.
Item number 12.
This matter, it is challenging the assessment order issued by buffer officer involving section 74. In the initial period that 1918, and as per board's instruction, it should be 73 because there is no fraud or suppression of fact. Everything is available in the portal.
That can be examined by the operator.
You go there in the appellate authority and do it. You are within the period of limitations. Are they?
Power case also that some matter, another matter there, in case of not there to pay because of paid in ITC.
This is irregular assumption of jurisdiction.
In ITC clause, it
This
is not
is irregular assumption of jurisdiction, not illegal.
the cover case.
Power case.
No. I can like cover case.
It's a factual science.
One
Tax has been because less deposit now.
then out of 2.53, 242 deposit. And the ITC utilized that too is not required to pay interest.
I could not wait for the RU.
Right. We have mistaken.
To my humble submission is not applicable, my lords, in this case. In this case, my lord, which my learned seniors is relying upon, in this case, my lord, the entire tax was billed. But in this case, the tax has not been billed. from his own government, the tax, less tax has been paid. 74 is attracted.
73. There is no fraud. The gold instructions in there.
Yeah, what is the allegation?
There is short payment of tax, no? In government data,
Not third party, ITC.
third party companies.
Not the ITC, government's
He has
data.
not, the supplier has not uploaded or what?
No man. He's a worst contractor, man.
Worst
As
set
per
of
the
service.
Wamish data and 26 years, my lord, the turnover which has been reflected in 26 years has not been shown in GHR 3 given.
That paid out the GST.
In his own admission, my lord, as para is
That
page
are-
6, my lord.
They are mentioning that here.
Para 6,
So, form number just 6.73, not 74. Not 6.
and may kindly see page 6. The tabular form, the learned senior has mentioned the figures in a tabular form.
But this,
It's only 11,000 rupees. Now, short payment of 11,000, that students.
That will pay, you will,
this I think, the general. From the medicine text paragraph 2, it appears that case was relating to only section 50. That is interest. By virtue of retrospective amendment in section 50, there was certain facilities given to the dealers for this particular period.
But
So in that context, we have passed that order.
in the second one was the entire payment was made. Here you are making a correction that out of 2,53,000 you have paid 2,42,000. That means the entire amount has not been paid. How can you claim a parity?
this section 70.
So what? You go for an appeal. Appeal is available? No.
See,
Let the matter is limited to the. Let the argument limited to our arguing authority.
Very difficult, sir. What is the penalty?
Penalty 70%, that's.
100% penalty, my lord. Tax to the equivalent to the tax amount. my lord.
Tax amount is?
Tax amount, my lord. Allows 1,41,000 each, means 282 total. CGST and SGST both together.
282.
Yes, ma'am.
2,80,000. Penalty is equal.
Penalty is equal.
So total demand is 5 lakhs and all.
560.
First matter. The second matter,
My second matter is different, different.
Second matter same also. Here enter tax paid.
Actually, the entire tax is paid after issue of the original order.
other agreement, 8 lakhs, 4 lakhs, 4 lakhs.
Yes.
You not consider the reply of this.
This is also the same. Yes, settlement. First of all, when I filed this matter within period of limitation.
No, madam.
period. It should have done homework, sir.
In the month of December.
December.
The order is of January 2025.
What to do, sir?
My request,
We are bound by our own judgment now.
my matter is admitted to arbitral authority.
How can we, under what provision of law, tell us? Can you show any provision which can be done, which we can invoke?
Board inspection there for the initial period, they can issue the section 74.
The question is of our entertainability now, the relief which you are seeking, that is the whole problem.
I'm requesting for 73 only.
That is what you say that it should not be invoked 74. It should be under 73 at best. So this circular you are relying on, but the difficulty is entertainability. You may have a good case, but you are out of time. What to do? Concluding line. What to do? How we can pass an order? Tell us.
Let us see that,
If we come up with 28, let us see if we find something.
This
Item.
item was the same, but that was winter tax day.
Both matters will be there. Let us see.
Item number 13.
Things regarding the non-constitutional.
Item 15. 14 is withdrawn now.
That's a good job. 15.
Item number 15. Let's hear it. Yes. Item 16.
Engage senior advocate. Who? It's not also engage senior advocate. Only also. 2 weeks.
Item 17. Item number 18.
Society fully owned by the state government under the control of the works department. This assessment made without opportunity and the appeal is now pending. So I have multiple prayer, but I am only insisting the prayer paragraph 3 measure. So only my prayer is that my appeal may be decided within a limited period. And I made a representation under Annex
Why you are not deciding the people?
This is a state of, it is coming under the state definition of state.
Why?
Under the
No, he has Edwin Gravas, he has approached and filed an appeal before the CIT appeal. He is saying that this appeal may be disposed of. He is not insisting for any other prayer. Only thing is expeditious disposal of an appeal. How can you stand in the way?
Whenever the recovery proceeding has been initiated.
That is the appellate court, the appellate authority will take care of that. If you dispose of the appeal.
And
If we succeed, then what will happen? Everything will go.
Yes.
But you dispose of the appeal.
Department of Power, order my to submit to stay a petition on
Already
subject to payment of
6 lakh, there is a conditional stay order already complied by. So stay order is also complied with. I am really at loss that when you are standing and obstructing the order for disposal of the appeal, I am really at loss. How can an authority say that I will not dispose of the appeal in time or place? What?
direction.
Challenging the assessment order. Come on,
Item 19 is consequences.
All three matters.
Yes.
Item number 20.
Here for next week.
21.
Item 21 applicants.
Item 22.
Your permission can it be taken up next week?
Item 23.
May I please the answer? Here the petitioner was a licensing inspector for on-shop. His shop was closed in terms of that honorable affected decision that state of.
500, yes. National highway.
National highway and state highway. Subsequently, it was modified to 140 meters as per the safe.
Beyond 200.
But the shop was closed. Then, my lord, I filed an application for safety. That is annexure.
What happened?
Thereafter, my lord, in month of 6th March 2025, I filed applications with all land particulars for shifting. Now they have directed me to deposit the excise duty with fine and towards MG shortlisted MG. During that closure period, your lordship has already decided in a case that when the closure is involuntary, so the license is not required to pay.
So
that is decided.
Of an order of the court. They are not responsible for the closure. For that period, how can you settle this with the responsibility?
There is some factual aspects. I have received instruction. We file a counter application.
What factual aspect?
Let it come next week.
Was it not closed by virtue of an order of the Supreme Court?
Your lordship, sir, in a self.
I know, I dictated it.
Yes.
Was it not by virtue of orders?
So that the interim order is concerned at page 75.
Yes.
It relates to that period where they were not permitted.
But there is
Is
no
it?
currency of license, Miller. At page 75, by deciding the case of the petitioner, Miller, the city collector of Bhadrak has stated at page 75, Miller, although the proposed site is situated beyond the restrictive distance from any objectionable site, as enshrined under order the rule 26 of Odisha Excise Rule 2017, as per report of the inspector excise, but there is no currency of license of the on-sub on this date. Hence, there is no scope for shifting. Further, the applicant has not paid the non-refundable application fee for the shifting of sub as fixed in excise policy for the year 2025-26.
So that is now question is that this is the non-refundable fees he has to pay. But what about the demand? Yes. That is true, you can. But what about the demand of that period?
Yes. The next paragraph.
Yes.
The table.
What is the yes?
An MGQ for the
Yes.
current year 2026 is to be lifted by the end of March 2026. Up to November 2025, the accumulated MGQ for the South is going to. Then you yourself.
The last part, Miller, the last para also, Miller. Now, therefore, the applicant is instructed to take steps for continuation of currency of license for consideration of the shifting procedure.
Well, even though I am ready,
Pilot
in the current year, 25-26, I paid the all statutory fees. I leave the MGQ, but I got to areas because they have closed. I have already given a proposal since March.
23, 24, 24,
Yes,
25.
that is the.
That was within that particular period of when the Supreme Court judgment was operated. Now, how can you do that? If you cannot run the shop because of the skinned orders, the people can be saddled with no result. No.
That will be taken for instruction only. I will take it on next week. Last time it was common.
Next week.
You have made application for 50.
Madam, on 6th March, I have filed. 6 March 2025, Rule 51 says all applications should be considered within the period of 2 months. They are not.
Item 24.
The petitioner has approached the Supreme Court against the demand notice, and the Supreme Court directed the state government to consider the demand notice and as submitted by the reply by the petitioners. Now, the improved order at page 62 annexure 30. Here, joint three petitioners, joint order has been passed. But in respect of serial number 2, this Honorable Court has already been admitted and stay has been granted without similar matters. The other 2 matters is Lordship's today. I am challenging this order where the collector and commissioner both have recommended, but because this is relating to 2021 during the COVID period. The shop was an operation only 2-3 months. About 7 months shop was not operational because of due to number of restrictions imposed by the government. So, collector and commissioner both have recommended. There's 2 documents under Annexure 7 and 8 has not been whispered by in this tribunal. And on that apart, I have given 2 letters of the government and excise commissioner where they have allowed carry forward of that shortfall MGQ in the subsequent year. That also not been taken into account.
This
4 annexures have not been taken into account, which have been given in the reply.
is a non-application of mine.
Yes.
Apparent. If those documents were there, will you not take stock of those documents and deal with it?
My son, pilot out this.
Then we are staying the entire demand. go on filing the counter for all members. It's not a device to delay. They say that in the reply, they have relied upon certain documents which have some bearing. Is it not your duty to take into account those documents by deciding the?
That's a shock. Take into account or not, I accordingly
That will be
seek.
reflected from the order. Can you include something or exclude something which is not there? You can't. And those, there's no remnants of those documents having considered, then what remain? They have said that the authorities have allowed its MTQ for them to be elected in the next year, everything. Why in this case the discrimination is so?
7, 8, annexure 9, 10, 4 annexes. Nothing has been used for.
Can I grant it some time and it's like, take the instructions in the.
What is? Why it was, when it was served to you?
Let's actually save the file last night.
I think, even my endeavor, even my,
This is,
even my deliberation in one of the symposia lacking an issue has not been attended. And it has gone to a deep ears.
thought for instructions.
Deaf ears, it has gone in a deaf ears. Nothing has.
It's a sought for instructions, but I have not received it yet. I've already sought for instructions in the matter.
Stopped it when you are allotted a week yesterday, when you sought for an instruction yesterday itself
Yes, ma'am.
or today morning. Why? When this writ petition was served, way back, when?
December.
December? What constrained you or your department not to take an instruction? Next week.
Item number 25,
Both connected matters.
item 25.
Subsequent development has been taken place. I want to amend the seed application.
Submitted by the council.
Not a single person. They are not filing the.
It's a process.
This is the, I think the recurring, feature from.
1 year,
24.
1 year back. It's
2024.
Yes, Lordship.
Every time covered matter, 180 ml, we are doing it, filing the cases. Why don't you come in one case, file your counter, and then do it, let us decide.
We file shortly, ma'am. After the file shortly.
The difficulty, you are still young, do not say.
It was made functionally rented house. The house owner issued notice to vacate the premises. Immediately I deposited the statutory fees of 3 lakh with a shifting applications. Then there was a public notice, this is a mandatory provision that was issued, madam. Then objections were invited. Lordship may see the public notice that page 17 annex of 4. Lordship
is
17 annex of 4. Lordship knows that is the mandatory period.
Yes, I know.
15 loads. Then Lordship may see the annex of 5 6. Objections were received, that is 22nd October 2025, much after the objection period, 15 days. Taking in this objection, 3 objections, my shifting application has been rejected by the collector. Only because your lordship has 3 judgments in September, October, and December. 33(2) says 15 days is mandatory. Where any objection received, that is to be summarily be rejected. They have rejected that part, my lord. This and then 26, my lord, if there is any restrictive distance, the government has to consider it because government has power to relax that provisions.
And sir, after receipt of the application by the petitioner, an inquiry was conducted wherein the objection for receipt, the objection have also been attached. So,
What he's saying is that our judgment is.
All judgments
That
are-
once the timeline is given. And there is a specific provision under Rule 33 sub Rule 2. That no objection after that timeline shall be entertained and shall be summarily rejected. Then if these objections are beyond that timeline, can you decide
yes, minus these 3 objections were received within the timeline, the rest they were received.
where you are
rejected.
stated? In the stipulated time period.
Minus last para.
Page 78.
Only 3
Page
numbers.
Page 79.
Last date was
That is object.
that is of public notice. Last date was 6/10. 6 October 2025. Last date.
Stipulated time was 6th October on or before. So the
10 was the last date. But the lordship may see the annex. Annex of-
That is received on 26/9.
They have filed objection 22 October. All objection on the 5 and series, my lord, from 10, 19. 3 objections were filed. All are dated on 22nd October 2025. That is after 9, for 16 days.
Where do I get that?
no, minus if the objection may be seen except 610.
This is received on 6/10, sir.
610 minus.
Yes, yes, there is a receiving endorsement.
But the 3 objections,
Well, I have objections. One is
one is from some Maji, Abhay Maji.
I can't read the name.
Abhay Maji, my lord. And
But I do not know. What is
second
this?
in
Another
Odia,
one-
The date is 6/10. One is from Pratima Behra.
Patia Behra, that is, I have also.
6/10. 6/10.
Then, my lord,
And
another
is. Who is
510
it?
minus.
another, my lord, Deepak Kumar Chandra Sahu. See, all are, my lord, the top, they have reflected the date.
This is also received. So. Maji,
Yes, my lord, Maji.
that is on 6th.
Maji, my lord,
6th October.
but I have, my lord, this is all are, this is
No, these are all within 6. Sorry.
then, my lord, 26, Rule 26 says, any restrictive provision, they have to recommend.
Well, that is what they have to take a decision. You can't put it in this way. You must have a statement. Do one thing, we are permitting a very short affidavit annexing this because that's the only ground.
Yes,
Just bring it on record.
My lord,
yes.
next.
By Monday, do a short affidavit.
By first day. Next week.
Next time. We
I think 46 orders matter. Extension of time to file document. Already pre-reporting has been made. Last case. Already made. Only extension of time to file appeal because within the time fixed by the justice does not been filed because of the cancer treatment of the patient. 46.
46.
It is not reached before.
Yes, ma'am.
Yes.
Item 28.
But beginning from where I last left, if also you recollect, I said that the paragraph 29 with respect to the ONGC, this is a Glaxo case, Manoj. The paragraph 29. That the third line from the bottom, if you also should recollect, that paragraph 29, 19.
Yes, ma'am.
Placitum G. The Lordships will see that. Doing so would be in the teeth of the principles underlying the dictum of a three-judge bench of this court in ONGC. In other words, the fact that the High Court had wide powers does not mean that it would issue a writ which may be inconsistent with the legislative intent regarding the dispensation explicitly prescribed under Section 31 of the Act of 2005. That would render the legislative scheme and the intention behind the paragraph 19 of Melodic Laxo.
Placitum G.
Placitum G.
Yes.
Prior to that, they are discussing about a reference of a discussion of a three judgments from full court of a Gujarat High Court, that is Panoli, and then the electronic case of Andhra Pradesh High Court. And here the full court is referring to those, and then they have decided in favor of the SSE. While this court is discussing at paragraph 19 beginning, we may now revert to the full bench decision of the Andhra Pradesh High Court in the Electronics Corporation of India, which had adopted the view taken by the full bench of the Gujarat High Court in Panoli International, and also of the Karnataka High Court in Phoenix. The logic applied in these decisions proceeds on fallacious premise, for these decisions are premised on the logic that the provision such as Section 31 of the Act of 2005 cannot curtail the jurisdiction of the High Court under Article 226-27. This approach is fallacious, faulty. It is not a matter of taking away the jurisdiction of the High Court. In a given case, the SSC may approach the High Court before the statutory period of appeal expires to challenge the aforesaid order, assessment order, by way of a writ petition on the ground that the same is without the jurisdiction or passed in excess of the jurisdiction by overstepping or crossing the limits of jurisdiction, including a flagrant disregard of the law and rules of procedure, or in violation of principles of natural justice, where no procedure specified. The High Court may accede to such a challenge and can also non-suit the petitioner on the ground that the alternative efficacious remedy is available and that be invoked by the writ petitioner. However, important here, Melo, this is a second alternative. However, if the writ petitioner chooses to approach the High Court after the expiry of the limitation period of 60 days, prescribed under Section 31 of the Act of 2005, the High Court cannot disregard the statutory period for redressal of the grievances and entertain the writ petition of such a party as a matter of course. So they say, even prior to that also, there is a rule of exceptions for us. Then post also it can entertain. It can, only with a view that it should not be a matter of course. That's what is the second component. And then it says, doing so would be in the teeth of the dictum of a three-judge bench of this court in ONGC. In other words, the fact that the High Court has wide power does not mean that. I've already read it. So what the court was saying, because the parties were saying that the three-judge bench of the ONGC, that may kindly be read it differently. The court was saying that no, we will not read it differently. But the factum is this: what is ONGC law? ONGC was rendered. I'll give you the judgment of a copy of the ONGC. My Lord, we just kindly have a look at it. It is actually rendered, my Lord, with respect to a statutory appeal exercised by the Supreme Court. Supreme Court in that judgment, there was no discussion whatsoever. Not on the issue of 226 or 227. What I've done is I have also given a layout of that judgment for your lordships. Easy reading. In that ONGC, the discussion was the section 125 of the Electricity Act and the condonation of delay of the section 5 read with section 14 and 29 of the limitation. And the court said, for a 1 day also we cannot condone. And they are all discussed from the paragraph number 2 to paragraph number 10. Let me give you another factual background in this. Also, his background is very interesting facts in this case. The interesting fact in this case was
Nothing, no interesting fact. It was an application was taken out by the ONGC before the Regulatory Commission for refund of a particular amount.
correct. Yeah.
And the judgment was sought to be challenged before the Supreme Court by virtue of section 125 of the Electricity Act.
Correct.
It provides that it has to be filed within a certain time. And the program also gives the power to control the ticket up to a maximum period of 6 days. Now, there was a delay of 71 days.
11 days actually. Post, yes.
71 days. That means 11 days beyond that 60 days.
Once, yeah.
So the Supreme Court condoned the delay.
Correct. At the first test.
And they condoned the delay, and then notices were issued. When the other side came forward, they raised this 2 points. First thing is the condonation could not have been done beyond the outer limit which has already been fixed. Second is there cannot be any condonation of delay without affording an opportunity
Correct.
to the other side.
Please.
So these two grounds it was said. Then section 14 of the Limitation Act, then the other aspect of the Limitation Act were taken into account.
Correct.
The court says that when an outer cap has already been fixed, it would not be within the jurisdiction of a court to condone the delay beyond it.
Statutory court.
So it says that I understand what you wanted to say, that this power, this ONGC actually emanates or originate from a statutory appeal, not under Article 226 or 227.
No.
When a statute has fixed the outer cap or outer limit, then even a Supreme Court cannot do it in exercise of Article 142 also.
No.
Because they were exercising the jurisdiction as an appellate court, not as a court of constitution or a constitutional court. I understand that is what you wanted to ask.
No, yes. That's my conspectus of my limited submissions, which on the last day also I said. So what happened in this case? The court did not get into the delay beyond the 120 days. That is the entire case.
This is the Glaxo the Supreme Court says that you say that it is on a different footing. But whatever the logical inference or the ratio which can be called out, that once the outer cap or once the outer limit has expired, then in that case, why one will entertain the proceedings? Even 227 or 226 should not be involved.
It says
you are putting an emphasis on the word in ordinary course.
That's the
Ordinary
language.
course means on a mere drop of the hat or a mere on an ipsy dixit of a prayer being made in this regard.
Correct.
But according to you, this ordinary course has to be read in a more pragmatic and more purposive manner, that all the cases may not be a case to interfere, but there are exceptional and extraordinary cases where the appellant was prevented from approaching, or the order itself per se is perverse, contrary to the provision of law, even against the public policy. Then why not 226 will be assumed?
My first submissions were not in this regard, that you allow me to enter into the main gate, then I'll tell you about what my...
No, allowing, there is a distinction. Allowing to enter into the gate
I'm already there.
maintainability.
Yes, I'm already there.
Is a maintainability.
Correct.
Maintainability, the
Not an
Supreme Court
issue.
has also not said.
Yes.
That maintainability is not
Please.
maintainable.
Please.
The second question is
Entertain.
the to have the visit to the entire infrastructures of the structure. That is called the entertainability. So the Supreme Court says, why you will entertain? Don't entertain.
The Supreme Court, the 5-judge constitutional bench, my lords, your lordship should know that in the year 1961, I have a judgment of that. It is, so what it says that the court will exercise the discretion in a judicious manner, because Limitation Act doesn't apply to the 226, my lords. Only thing is that when your lordship is exercising constitutional function is to see that whether the delay is of the nature which will prevent or will cause the prejudice to the party of a different proportion or extraordinary proportion. So therefore, there has to be a higher threshold of evaluation. That is perhaps this particular judgment in Lords is trying to is infer. So what the court is trying to say, that because there is a limitation qua a statutory process and you did not exhaust that, and you came to us directly under 226, the court should not be oblivion of the existence of a policy. And to that extent, whether in a given case, that therefore, in a given case, what should be the temporal or the factual elements that your lordships or mitigating elements that your lordships will adjudicate as to whether this your lordship will entertain. So to the extent of the entertainability, my lord, so far as the adjudication or justiciable elements of the factual delay, your lordships will has the jurisdiction to adjudicate. That is exactly the Glaxo says. What therefore the entire endeavor to explain to this honorable court, my submission is that Glaxo itself per se has not taken out or has not laid down a binding element of law or a precedence of a law to the effect saying that the moment 121 days, you can't even entertain. It's not even the Glaxo's case. Because the Glaxo invested the more than 50% of its time from para 2 to 13 and then the para 23 in examining the delay. Glaxo itself. So to the extent of referring, saying that if you do, in fact, I do not wish to add word into that particular paragraph 19 to explain the ONGC because I don't want your lordships to get into that as to whether this is an inadvertent error or not. But in the factual matrix, therefore I say that, with due respect, I do not wish to take your lordship through that route. What my humble submission is that neither the ONGC which was relied upon is on the facts of the case, A. B, even the Glaxo itself says that yes, in a given case, of course, you don't decide in a routine manner. You have to factor that there is a provision beyond which statutory procedure doesn't permit that entry into the limited. That is what the ONGC is talked about. Now, if your lordship will see the series of that maintainability, what I have given one of the series of written notes, your lordship may kindly just have a look at it for a moment. Last time I have given your lordship's written note on maintainability. This is one of the written note of dated 9th of September. For a moment, just also may have it. Now, therefore, if the entertainability, yes, Lords, this is one is the last 9th of September. There one written note on
Maintainability you have given.
Yes, Lords. There are 1.5 page. That's of 9th of September.
Yes, sir.
Yes, Lords. 1.5 page, Lords. What I have given one of the three conspectus, one is the maintainability. Of course, we are not discussing the maintainability. We need not have it. We need not have. Then one of the next question is the limitation. And of course, the res integra. What I submit for the res integra, I've already explained that the Glaxo has to be read it in its own factual matrix. And in our case, the court also, Glaxo says that the court has the power to entertain, provided it has to take note of the limitations, that statutory limitation, the external time period. And then in the particular facts of the case, you can, because in the case of the Glaxo, they did not exercise the power. I mean, of course, Glaxo was with respect to also 226. But in that case, the matter came to the High Court after 1.5 years, after exhausting the entire processes. And if your lordship will see the page number 2 for a moment, this distinguished facts of the Glaxo vis-a-vis the fact of our case. Like in my case, the first matter, the defective and incomplete assessment order, 30th of August 2024, was passed with 4 missing pages. I've given an affidavit to that effect on the 13th of October. Then, that is received on 18th of 10th, 2024, is yet to be served, causing no trigger of a limitation for appeal. A fact not heeded, replied, and petitioner's appeal in ST 4 on the section 85, dated 2nd of January 2025, was also not even acknowledged, citing there is a delay beyond 4 months statutory period. So when I even filed that statutory appeal, they say that we cannot even entertain. So even at the stage of all of the registry level, they did not even receive it, the officer level. Then second point, the peculiar unique design of the, that's a substantial question. I want to say that this is in a case where I am not before your lordships. I wanted to show what the peculiarity of the design of the section 66 EE, whereunder I was levied. So that means I request your lordships to get into the merit of the matter. Unless we enter into the delay, we'll go beyond the delay. How do we enter into the merit of the matter, which is a mostly substantial questions of law? Then the third point, here in this case, the kind of my submissions as far as this my appeal reach is concerned, they did not have the jurisdiction because I am in any case, is never registered. A. B. I am never levied also service tax. C. I was even otherwise also I was exempted under section 93, and it has not been factored, not even adverted to, not even discussed despite submissions made in this regard. I also filed an application to the effect of saying that you don't have any jurisdiction. Never ever in the history, right up to the change of regime, from service tax to the GST tax till the 2017, I never was a registered SSC because I'm NHI, National Highway Authority of India, I'm a government entity, and I'm also exempted under additional through the clause number 12 and 13. If your lordships will see those, which is I've given in the annexure 2 minutes, running from the page number 11 onwards of my writ petition. Running from the page number and the relevant page of 16 to 36, and the relevant page is 27 and 28. 27 is important. Malon may just have it. This is an exemption. This is a mega exemption notification of 2012, 20th of June, running from the page number 26 to 36. And the relevant paragraph is the 12 and 13. What it says, and the paragraph 12 is at page 27. My lord has it. Services provided to the government, a local authority or a government authority by way of construction, erection, commissioning, installations, completions, fitting out, repair, maintenance, etc., renovation, alteration of a civil structure or any other original work meant predominantly for use other than for commerce or industry or any other business or profession. Now your lordship may turn to next page, paragraph number 13. Services provided by way of a construction, erection, commissioning, so and so, of a road, bridge, tunnel, terminal for road transportation for use for general public. Means paragraph 12 and 13 sums up not only the nature of the activity which is exempted, construction of the roads, bridges, all these activities which the NHI does, and as well as the paragraph, the serial paragraph number 12 at page number 27, it says that the local authority, government bodies, any services rendered to them, like in this case, fellows, the services are rendered to me by the contractor, and I in return serve it to the government. So therefore, I am already exempted under 12 and 13, never therefore was registered, never therefore ever levied any service tax till the change of regime. The demand started but not only after the regime changed, and that is in December 2017. And pursuant to that, the so-called notice, despite giving all replies, and more so an application in 2018, which is as page number 'I have given an application also questioning their jurisdiction at 97 and 98. That was also not disposed of. That is 26th of June 2018. All of a sudden, my case is they have issued a so-called notice on 29th of March 2019 when all this so-called inquiry was conducted. Beginning from the page number 4280. They issued a so-called notice and almost demanded everything in the so-called notice without adverting to all these provisions of law. And after 5 years, they issued me a notice for hearing. That is at page number 134. Well, I saw that. Here, if you also will see, there are 2 dates they have fixed for hearing. With reference to the demand comes so-called notice, reference above.
26, 8 and 30th of.
Correct. Now, this notice never reached me, and all of a sudden, even though there are 2 dates were fixed on 26th of August and 30th of August, the demand order purportedly issued on 30th of August on 15 pages. So that means there is absolutely no opportunity of a hearing was given to me. No consideration of any of my representation given there. No questions of law adverted to. And therefore, I say that you have violated section 93. Therefore, your lordship is to exercise the jurisdiction. Not only on the violation of principle of natural justice. And if your lordship will see my additional affidavit for a moment, and then I'll get into the impugned order portion. that is nothing but a copy paste of the so cause notice. This is the additional affidavit which I have given now. May I read it? The paragraph number 2 onwards, the relevant facts which I have. That the chronology of material facts pertaining to the yes, pertaining to the issue in hand is given hereunder at this stage for the bare perusal of the Honorable Court in view of the preliminary objection raised by the opposite party at the threshold to mischievously deprive the petitioner from its constitutional entitlement for judicial review against an illegal demand order issued without statutory jurisdiction and in violation of very safe statute under which it purports to exercise its power. 2.1. The activities of enforced erection, management, and so on and so on so of a bridges and roads and the 2012 circular. Correct, notes. This is of which is I've given it below the page number 26 to 36. Then paragraph number 2.2. I said that I'm never registered, never levied, neither before the 2017 nor thereafter. Then 2.3. That letter of 22nd of December 2017 for the first time was issued after 20 months, citing that some inquiries to be done with effect from the 1st of July 2012. Then paragraph number 2.4. Here is another letter that 22nd of December was issued after 20 months from the date of the last notification, which has invoked a clause clause number 57 was added. That is at the page number 38 and 37 and 38. I'll show you the notes for a moment. 2.5. That means I furnished everything and pursued explaining the entire case, but they did not hit to it. And then the paragraph number 2.6. I filed one of the application, which is 26th of June 2018, questioning their jurisdiction, which is yet to be adjudicated. 2.7. During the course of the engagement of the office, they did agree that yes, it involves a pure question of law. And without first deciding the jurisdiction raised there on 26th of June 2018, mischievously issued a so-called notice on 29th of March 2019. That is for a period from October 2013 to June 2017. Then 2.8. I filed a written note on 3rd of June 2019, which is also an ex-biological institution. And in fact, they have in the meantime, without even adverting to the written note, they issued the notice on 20th of August 2024, which you'll also have seen that at page number 134, fixing hearing for 26th and 30th of August 2024. Incidentally, interestingly rather, on 30th of October 2024, a 15-page, a detailed order is issued. When you have already fixed a date for hearing, that means you were already having an order ready. Because the moment I'll go there, you will hand it over to me. That's why this order was handed over to me only on the 18th of October. That is not the 30th of August, but it was handed over to me 18th of October. And in this order, there is a 4-page missing, which I have intimated on 18th of October itself. Then I filed the appeal. That is on 2nd of January 2025. But they refused to register this appeal on the ground that since there is a delay. And this delay, I have explained in paragraph number 2.10. Having realized that the matter involves pure question of law on the issue of jurisdiction of the opposite party department, where just opportunity of hearing was not accorded to the petitioner, the present petition is preferred to challenge the impugned demand order, so and so and so. After obtaining all necessary documents from respective document and professionals who were assigned and were handling them since 2017, there was some delay in filing the petition, owing to the fact that the officer concerned, who was entrusted with the case, took leave due to his ill health and so could not be processed on time. Only after compilation of the full file, this was filed on 9th of May 2025. And so far as the trigger of the limitations concerned, I've given one small written note with a 1-pager, where the Honorable Supreme Court, the 5-judge Constitutional Bench judgment has stated the CB Gautam, saying that though it is an Income Tax Act section 269 UD, where it has stated that if a ground is not given, because series of limitations affecting the rights of the parties gets triggered, like Arbitration Act section 31(5). There's one judgment on that also. And then 269 UD in the Income Tax Act. The limitation of this first period and then the further period. is basically, my lords, is expediting the process of a statutory process. But it is never meant to really, so to speak, my lord, to deprive somebody who is deserving. And that the court will exercise that power unto 26. In this case, my lords, the Constitution Bench, 5-judge Constitution Bench, Justice C.V. Gautam, it has stated that where the rights have been impeached on account of a order, and that order is not delivered, rather it should be read as a receiving. Mere delivery is not good enough. So therefore, the section 12, your lordship will pick up in this case, my lord is not bound by the limitations. But when your lordship is seized of the fact that the proviso of a statutory provision limiting the further period is to be factored for the purpose of entertainability, my lord will definitely be getting some help in the sense that section 4 to 24 Limitation Act, and it is not barred. Section 4 and 24 also is also a policy, though it is a general policy. It enters into all special statutes through section 29(2) of the Limitation Act. So much so, my lord, the section 3 through section 29(1). Section 29(2), my lord, makes the provisions of 4 to 14, 4 to 24 make applicable, and your lordships can always look into it. Like in this case, 18th of October 2024, it was delivered to me. I sent a letter same day itself saying that these 4 pages are missing. Please give it to us. Till date, there is no reply. Therefore, I have given that affidavit in this regard. And here, my lords, the second written note, your lordships may see that the maintainability, that I don't need to get into that much because we have entered into the entertainability and Glaxo is not impacting as much. That's my case, my lords, unless my learned friend says that yes, Glaxo is impacting. This is a written note which I have given it, my lord, on alternative forum, that is on the 10th of November. And I say, your lordships exercising discretion as a matter of policy and discretion, policy and convenience. This is 9 September. This is one of the 10th of November 2025, second written note on the maintainability alternative forum relief. What I've done, my lord, the appendix A for a moment. Your lordship will see that. Yes, my lord, yes. But along with that, my lord, there is a written note which I've given it on 13th of November. The 10th of November.
Let him have a copy of that submission to my associate, my lords.
Yeah, copy there. The copy. I can.
The notes of submission as well as the compilation, my senior has.
No, it was actually given on the last occasion, the 4th of December.
No, it was not given. It was never canvassed. The first time we're advancing the submission, so how can it be given?
So by proposition, I have given a one page. Rather, it is a kind of concising the entire jurisprudential development on the alternative forum rule. What I've done, I've said that it is actually the constitutional functions, your lordship's constitutional functions to undertake the judicial review. My lord's constitutional function, it is not the charity from the parliament. That is first submission. Second, my lord, the Article 226 says your lordships have power to enforce the fundamental right and any other purposes. Now, when my lord has exercised, is insist of the jurisdiction of 226 or 227, my lord has, in exercise of the discretionary, my lord, exercise of power, have prescribed certain rules, self-imposed rules. What are those? That when there is an alternative remedy is available, that's one. That's what we call it as an alternative remedy rule. That there is an alternative forum is available. Or there is second, my lord, when there is a factual elements are disputed in nature, then your lordships always relegate to the civil court. Number 3, my lords, when the parties, my lord, do not come with a clean hand, or the conduct of the parties as such, the court will not entertain it. So these are the exceptions which your lordships have carved out. And in that exception, there are again another exception to exceptions your lordships have carved out, to the extent of saying that bottom, that these exception to exception, that despite the fact that the alternative forum is available, your lordship will still exercise the power if there is a constitutional infraction, statutory infraction, or for that matter, my lord, there is a challenge to the constitutional validity. These are all the lordship's settled position of law. But what I have done is one pager. I have given it a structure to show that this exception to exception is nothing but actually lordship's substantive constitutional function. In other words, in my case, if there is no time limit, then your lordships have unbridled power to enter into it, except to the extent of the
That is different. If the limitation has not started ticking.
That's one argument.
Then in that event, the question of this applicability of paragraph 19 of the Glasgow
will not come in play.
Because it is not
Trigger.
started. It is not recognized. There is no dispute to this regard. Only thing is that once it has started ticking and it has already crossed the outer limit, then in that event, what should be the role of the High Court while entertaining such a writ petition, challenging that order? This is what we are really pondering upon or really deliberating on that issue.
My lords, may I respond
Paragraph number 9.
to that additional affidavit that if it was not served on him, because lordships have indicated that, my lords may see that document that he has furnished regarding the supply of the order. My lords have annexer P9, the additional affidavit that he has filed, my lords, for a moment. Well, that is an undated letter. In the affidavit, it doesn't mention when it was sent by post, by what mode it was asked for. The department has verified it was never received. Such kind of letter is an subsequently fabricated document. I'm astonished that NHAI is a statutory authority, a governmental authority. Why would they resort to such kind of a practice? Well, in the affidavit, the reason he ascribes for rejection of the appeal is on submission of the demand.
Shown the birth only to.
Well, I'll tell you. There are two petitions before my lord. I'm hit by the second.
My lords, I'm addressing.
I'm not saying
I'm only referring to
I have not received anything. So far as the second writ petition, I'm hit by the limitation. Therefore, I'm arguing the limitation. So far as the first matter is concerned, my case is, my lord, the 18th of. Let them show that what kind of order they have issued.
2.9, paras 2.9 and 10. That was referred by my petitioner, my lords, 2.9 and 10.
No, they don't receive there. The problem is, I'll tell you, my lord, it's not like a register of the High Court.
Bundle of lies, my lords.
They receive it. This is not what my learned friend is actually.
Verified from the department, there is no such document received. Can he show by what mode it was sent in transit?
Well, and then come back.
Anything, my lords, it's a subsequent post-dated document. After filing of the writ petition, he comes up with this creative.
Pleading is concerned, please.
Yeah.
Importance of pleading is concerned. If you say that they did not receive the document, you could have precisely adumbrate those facts in your affidavit, saying that you tendered this document, they refused to accept it. No problem. Once you say that you have already tendered a document, yet they have not taken into consideration while passing the final order, then in that event, definitely they will have to show how you have tendered and when you have tendered the document.
I'll read the once again the paragraph number 2.12. Yes. Having realized that the matters involve pure question of law on the issue of the jurisdiction of the opposite party department, where just opportunity of hearing was not accorded to the petitioner, the present writ petition is preferred to challenge the impugned demand order dated after obtaining all necessary documents from the respective. That's a continuation delay. Yes, fellows, this is the page number para number 2.88. This is page 5, fifth line from the top. I say that only on 18th of October 2024, OP2 sent the impugned demand order dated 30th of August 2024, which was missing with her 4 material pages from page number 2 to 5. They actually gave it in the physical of the order dated 30th of October 2024. Petitioner, while its letter dated 18th of October 2024 immediately informed the officers of the opposite party department and sought the full demand order. Petitioners authorized, and this particular order was also sought to us in our office physically. Then petitioner by this letter.
He's saying two statements. My lords, he said he had gone to submit written submissions, then he got the order. Now he's saying that he's got it physically.
Authorized representative also visited the office of the opposite party several times, requesting it to accord the opportunity of hearing after withdrawing the demand order, and also sought full copy of the order dated 30th of August 2024. And the authorized.
You are relying on a particular document which is practically B6. What is that document?
Well, this is the
Which document you want to say that it has not been submitted?
My lords, this document annexer P9, which he is relying on.
P9.
My lords, and that additional by way of additional affidavit.
Page number 9
Yes.
is the affidavit.
Correct.
Page 8, my lords, he submits that he asked the department, because those pages were never supplied, he asked the department to supply the complete copy of the adjudication order. My lords, this document has never been submitted to the department. I have verified. Because this has never been sent.
You are banking upon a situation that once the complete copy of an order has not been given to you,
Yes.
at least it is an incomplete order. So definitely the limitation, how can it start? Because your right does not accrue. But he says that you never communicated that these 4 pages are missing.
Then let us see two different ways. First is.
Can he show in what way he has submitted, my lords?
There are 2 ways. Let us look at
He has
it.
prepared a letter. Can he show in what way this was submitted? By post, by email, by in what way, in person? He has to show a receiving in that case.
It is written there.
Doesn't show.
It is written there.
This is only an afterthought after the writ petition is filed, my lords. Because my lords, in para 2.10, lords may have 2.10. For a moment. Let me refer to your additional affidavit. Your affidavit. Para 2.10.
Yes.
He said, having failed to receive the full and complete impugned demand order, he filed one appeal. So he filed an appeal without a complete order. That's what his submission is.
Yes.
But the opposite party refused to acknowledge and register the said appeal on the ground that ST4 was not accompanied to the deposit challan of 7.5% disputed demand. So he approached the appellate authority without accompanying with the compulsory statutory demand. And then now he says, my lord, because he comes before this court, because the appeal was not admitted, that he says that complete copy was not submitted. Well, this is absolutely blowing hot and cold.
Not at all. Not
hot and cold at the same time.
Oh, that we will consider. You can't hijack his argument. I just thought that some very serious these are made. Whether what would be the interpretation, what the logical deductions that the court will derive. That's the another aspect. We will definitely do it after giving you an opportunity of hearing.
Let me respond, because he's saying.
Let him complete his argument. You can't hijack his right to begin.
My lords,
in the midst of an argument, you are hijacking a right.
My lords, I'll wait for my turn, my lords.
So, lords, what my submissions, as I now start from the beginning of my written note, the paragraph number 1, which I have, that's my sequitur. I say that, lords, when an alternative forum is not even available, as in this case, there is absolutely no alternative forum available. Post that period of 3 months and 1 month, I have no alternative forum available. Then where do I go? Now, there could be many reasons of not going to the court within a timeline manner. One is the reason which I have argued.
Alternative remedy is provided, but it is in a restricted manner.
Correct.
With limitation.
But after
no alternative remedy, it is not known.
And put it, alternative remedy was.
submission that I wanted to make is statute provided a procedure which is not a substantive law, it's a procedural law. And
What?
That's my argument. But I'll not get away. Well, straight away we'll get into that aspect right now. I'm just giving by sequitur to the extent of saying.
Then even a sequitur must have some nexus to the law.
I'll answer that. Just kindly bear with me. I'll answer as I go. No, I tell you.
As well as substantive.
This is
time passes.
I will
Then it becomes.
Is a CPC which has this procedural as well as the substantive part, both.
what my conspectus is this, the submissions that I want to make. Statute provides a procedure, like in this case, section 85, where it says that any person aggrieved will file an appeal.
That's
within
not a
X
procedure. That's a remedy which is provided to you.
That's
Procedure is something different than a right to appeal. The right to appeal is a statutory right. One cannot assume the right to go to an appellate court unless statute provides. So definitely it's not a how that appeal is to be regulated, has to be guided, is by a processual law or a procedural law. You have to thus make a distinction, substantive right and the procedural aspect.
Now, let me reframe it again. I think I gave a wrong impression Manoj, when I argued from that angle. What my solution on this though is that when a legislation, particularly the taxing law, there should be a distinction between a procedural law like a CPC, where two individual parties are fighting and they have their rights or liabilities and obligations, and it is the state provides a mechanism to govern those rights and duties and regulations. This is one part of one class of a legislation. There are second class of legislations. Now we are dealing with the second class, where the state is making a law and prescribing a procedure where it says that first I will undertake an assessment order because the claimant is the state. Unlike the other first class of a legislation, the rights and obligations are
Cannot the government go and file a suit for recovery? Can it not go?
Provided
Where is the difficulty? Can a litigant not go against the government and then assail in a civil court?
In that case, Manoj, the government is the litigant. I'm
again, when you talk about the powers to legislate, then we'll have to just think of the constitutional ethos on which the three separate wings have been established and recognized with the separation of their powers, respective powers. Legislative exercise is one, executive exercise is another, and the judicial exercise is the third facet. So one has to understand, if legislation is put in place, one has to see that this legislation is duly implemented. And what is the nature of such legislation? If there are different statutes are there, different statutes has a different remedies provided.
Correct.
That does not mean there's a procedure which is provided. It is what? The remedies are different. One can approach directly to a writ court, one can approach to an appellate authority, one can approach to a revisional authority as well. All these things that emanates from the statute itself, which has been legislated.
Correct.
So what we have to see that these laws, the fiscal statute, I am quite conscious, while interpretative tools are to be activated. So far as the fiscal statute, there are different connotations with regard to that.
Absolutely.
I'm quite oblivion of, there is no difficulty in this regard. But only thing is that what we are troubling at, or which is grappling at the situation is, there is a GST Act which is there. It provides a complete mechanism that how the authorities would deal with it. It's a complete, exhaustive code by itself.
Correct.
It also contains the right to appeal. Appellate forum is also provided. Now, suppose a decision, the action is taken under that particular statute. Obviously, you are an SSE, you can't go beyond that. You are supposed to submit to the jurisdiction, order is passed, remedy is also provided in the statute that you can challenge that order before the appellate forum. That does not mean that, because sometimes the procedural parts are to be treated in a directory manner, not in a mandatory sense. I know where you were heading. I am conscious of the Jajaram's case of the Supreme Court. That the procedure is a handmaid of justice, cannot be used as a jealous mistress. I'm conscious. That's why I interrupted when the moment you started. But that cannot be applied in this particular case.
I'm coming, Manoj. I think, Manoj, this remains res integra. That's my submission. the one which I'm navigating now, it's according to my understanding as of now, as I found out, it remains res integra and your lordships will be dealing for the first time ever. That's my solution. So I tell you how. When your lordships is dealing with those regulations or a law, which of the nature of the CPC kind of a regulations, laws, they deal with the governing the rights and obligations, related issues, be it a citizen, be it individual, be it a jurisdictional person or a government. A suit can be filed also against the government. So to that extent, this is not Salem Bar and all. So all right.
Even Section 80 is a repository of that recognitions. There is no difficulty. Notice has to be given against the government when you want.
Now, please understand the taxing legislation. I can understand the law. The largesse is given by the largesse is given by the government.
Largesse, when you talk about, then one has to consider that, is it really a largesse?
No, it's not. That's where I am getting into now. When it comes to the largesse, since the state is giving you a right, it's a statutory right. It's not your natural right or fundamental right.
True.
Since it comes with a right given by the court, given by the government has every right as a policy to put a condition attached to that right.
There is no difficulty.
And no difficulty. No. Then in that case, the appeal, limitations, all as part of that statutory mechanism
cannot be said to be illusory.
Yeah.
Cannot be said to be illusory.
I'm saying a little different. I'm saying, since you have given a statutory right to appeal under a MMDR Act, for example, MMDR Act.
True.
There is a statutory appeal and there is a limitation.
True.
Because the largesse has come from the government, it is not your own. Therefore, you have to be bound by the limitations given there. And then I say, when an appeal provision is prescribed in that class of a legislation, it is a substantive right to appeal. As opposed to that, a property which is mine under the income tax legislation.
Then what is the purpose of promulgating the Limitation Act? Because Limitation Act, the policy is, it's a fundamental policy of the country, which is also constitutional ordained that every litigation must receive a quietus. It should not remain perpetually open for all time to come.
Right.
It is not the destructions or a diminishing of the right of a particular person. Limitation Act does not destroy the right.
It still remains an ambulatory state.
It remains
ambulatory state.
Ambulatory state. Yes. There is no difficulty.
Correct.
But what hinders is the relief before the court of law.
Correct.
If you cannot get a relief and the court cannot grant you that relief, even if your right is still there or still exists, that does not mean that you will be favored with any kind of an order, because that right is a statutory right emanating not only from the statute but also from a constitution.
I agree. To that extent, there is no debate.
But why the periods have been provided for each class of a litigations or each class of a claim is to put that whoever is not vigilant, that he should not get this kind of a leverage, that whenever it suits him, he will approach the court and seeks a relief. Similarly, when a limitation periods are provided or statutory period is provided within which a person must exhaust the remedy, there is a laudable intention which is manifested therefrom, that a recalcitrant litigant who was just sleeping there, he should not be permitted to use this particular the forum in such a ransom positions that whenever it suits him, whenever he is woke from the slumber, he will just approach it. That cannot be a ground for that.
That is, as far as the public policy of limitation law is concerned.
Obviously.
Now.
Then in the Commercial Courts Act, now you are aware, series of judgments have come. If you do not file your defense or a written statement within a particular outer limit, there is no power which is provided upon the court or in the statute to condone the delay beyond the same.
Because that is the reason.
The reason is the object and the purpose underline the promulgation of the Commercial Courts Act. Because every litigation of a high value, which has direct and indirect nexus with the economic development of the country, that should be rigidly
Enforced.
And there is no question of any latitude to be given in this regard. Like Koilas versus Nanko of the Supreme Court in relation to a CPC Order 8, that court has an ample power, even under Section 148 of the CPC, to enlarge the period of limitations provided there. It does not, because one has to understand the nature of the legislation.
So the answer, therefore, I say.
And these kind of fiscal statutes, it has some impact on the I would say the management, the administration, the economic development, impacting several policies which the government comes, unless it has a source.
Take the example, my lord.
It does not have a source.
I tell you, my lord, why I say this, why I'm driving your lordships in that direction, is the fact that your lordship says the distinction between the civil CPC and the commercial.
True.
I'm giving an additional nuances to that distinction. The additional nuances, according to my respective submission, my lord, is this: that you have the option of the civil court, civil procedure. You also have the option of the commercial court. As a dominus litis, you are choosing which one you are actually invoking. Where the latitude of the CPC is there, but that latitude will not be there here. The state is making it position loud and clear to the extent of saying maybe one of the aspects is the commercial aspect, but the second, the credible aspect, which if I may submit, the state says that if you want to come for an efficient redressal mechanism,
but there is
then you come with
there is no concept of doctrine of election to apply. If it is a commercial dispute of a value which is more than under the statute, there is no option which is given either to go to a civil court or to come under. It is what the forum which is already provided. You have to approach that forum. Commercial Courts Act does not give that particular option, like a Consumer Protection Act, which says that the act is not what is that?
My lord, if I approach
is not in derogation of any other law for the time being in force.
In repugnancy.
So that's in case of even if there is an option, one can go to the civil court, one can go to the consumer forum.
No.
There is no difficulty.
I tell you, may I submit on that, at least to my understanding of the law, of the commercial law?
The Section 3 is the act is in addition to and not in derogation of. That is what is a issue. So it is an additional forum which is provided.
It is not mandatory.
It can be complementary or supplementary, but not supplanting the other forum.
Supplanting, like for example, Consumer Protection Act, Section 3. It says that in addition to, not in derogation.
True.
That's an additional alternative forum.
True.
Therefore, when somebody goes there, whether it's a commercial dispute
there is
or not,
no other option.
No, I'll tell you.
There is no other
Whether
option.
there is a commercial dispute or not, somebody has to give a declaration to that effect, to the affidavit. And then the Section 12A as an alternative.
Oh, that is a different, that is a pre-litigation mitigation is different. But one has to satisfy the definition of commercial dispute, which is originating under is a very expansive definition.
Correct.
Imbibed within itself the various things. I think up to clause 25 or 23. What are the commercial disputes?
May I, Lords, on this, may I seek a Lord's clarification on that, at least to the extent of this Section 3, particularly your Commercial Courts Act. It doesn't say that it is in substitution of the CPC. Just
No.
It is an addition.
No, that is under the Consumer Protection Act. I'm just talking about. Commercial Courts Act does not.
Well, Commercial Courts Act
does not contain that provision.
Is this that the Lord's is suggesting? The moment you reach the threshold of a figure as a subject,
that is what section 11 or a 10 has to be construed. Even any litigation which is pending before the civil court has to be transferred to a commercial court.
provided there is a declaration to that.
No, not declaration. It is not. It is the mandate which has to be given. It does not know. My own judgment is steering, I am saying.
And in that case, that's
My own judgment is there. There it was saying that the district judge was simultaneously exercising the jurisdiction as the suit was pending before it.
Right.
It says you can't. It is your duty to transfer it or transmit it to a commercial court.
This particular two mutually exclusive law, CPC and the commercial court.
It is not really one is supplanting the others. They all operate in their specific field. When a special statute has come,
correct,
then general statute
with a condition like these are
general conditions, general law.
Yes. So to that extent,
what is that maxim? Specifically or generally, or what is that? That I do not. I just forgot that maxim.
Okay.
The special statute will give and has no age over the general statute.
Correct. Not see, special law will always have a precedence over the general law. Now, what I am submitting here.
Non-delegable, special.
That is.
Yeah, that's a Latin maxim. And now, Manoj, what I am now making by submission, even for a moment, Manoj, if the CPC and the CR commercial courts are mutually exclusive for a moment, it's actually mutually exclusive. In that case also, as a dominus litis, I have all the options under the different statutes. And these are all statutes of procedures. To the effect, what my submission to this effect is this.
Again, dominus litis principles is a very difficult and a different position.
But I will suffer the consequences if at all I choose a wrong forum.
You can't assume the character of a dominus litis approaching a wrong forum.
What I'm trying to tell you that the state has given me the options of different laws. There are different procedures that are prescribed for a different nature of the list, and I have an option which one I want to invoke. What the purpose of making this submission is this? That
does it not indirectly? I'd say is propagating the concept of a forum shopping when you talk about it.
No, that is a forum shopping. Again,
is a forum shopping. I have an option either to go to a court of Balangir or to a court of Keonjhar or to the court of
forum shopping is different.
The Balasaw.
No,
I will just choose that.
No,
does not.
You respect about that.
There is only one concept because one court must have a jurisdiction. I know.
So
when a cause of action has arisen in a different jurisdiction of the court, then if you invoke one jurisdiction, you can. There is no difficulty in that.
As long as the law permits.
Obviously. But question is not that. Question is, when you talk about the efficacious alternative remedy concept, then one facet of looking at it is that the remedy which was provided in the statute can be said to be an efficacious alternative remedy. If it is not, then one can approach. It is absolutely different that the remedy which is provided in the statute is an efficacious alternative remedy. A litigant did not exhaust such remedy and then chooses to jump the same and approach the court under Article 226 of the Constitution.
But not to the extent of saying that when your lordship is exercising the justiciability of the delay, and then your lordship will exercise the justiciability of the condonation.
That is the one. If the power to condone is ingrained and in here, which definitely a constitutional court has, then in that event, justiciability all depends upon the various factors, the facts which is there involved in this, or on the basis of a given case, whatever is there. But if the power is brindled or abridged to a certain extent by statutory provision, which is what the GlaxoSmithKline says, then in that event, even at 226, you have the enormous power. You should not exercise such power because it will be opposed to a legislative intent or will frustrate the legislative aspiration which they sought to achieve by putting such restrictions in the statute.
Glaxo, your lordships have to see its facts. What it says.
Oh, I understand. That is what it says.
My lord, it says that the judge in exercising 226,
I will consider the routine manner. I understand.
not even routine, not even routine. It did not discuss about the delay at all. It says that 35% you have deposited, you go. There is absolutely no discussion whatsoever. That's precisely the Glaxo is frowning upon the court exercising it in a cavalier manner. That even you are not even discussing the delay. So therefore, it is not to say that just because you have come beyond the statutory limit, where the Limitation Act itself per se doesn't apply to the read court, and your lordships is guided by the constitutional principles and the function, then your lordships definitely has the jurisdiction and the entertainability so far as the read. Your lordships have to, in a given fact only, like in my case, in second matter, my lords, hardly 10 days. First matter, which I say it has never triggered. Second matter, it is 18th of January, the order was passed. I received it, I think, on the very same day. And the 3 months, if your lordships calculate, it is coming around May 18th. And I filed at the 3rd of June. So effectively, whereas the Glaxo is a 1.5 year, exhausted appeal, exhausted review, but only challenge the appeal order, did not challenge the review and the doctrine. There are multiple elements were involved, and the court frowned upon because by saying, why did you not adjudicate even on the delay? That's the Glaxo. So if we get into the Glaxo in a sense, para 19 by no means, as I have read out, there are two, if before, after. It says that if before, how you will deal with it, exceptions rule you can apply, or you will non-suit also. Number two, you can still entertain provided you don't do it in a routine manner. That means Glaxo is not an authority on the issue that post that period, the court has complete bar in entertaining the delay. So delay is a subject of adjudication and justiciable. Now, my lords, if I may then get into, my lords, this submissions of my written note where I stated that what I am driving, my lords, is as a unique proposition for my lord's consideration, that taxing laws beginning from, my lords, your beginning from 1961 and 66, Mirajkar and all other judgments, my lords, the court is dealing taxing issues in a little different way, as your lordships knows, and it is a special law. The court always is loath in interfering in the virus also. But what my submission to the extent of that proposition, that when a right is given to utilize in a particular manner, it should be used in that manner or no other.
Nazir Ahmed's principle.
Correct. So to answering that question, though it is not necessarily is my lords, frowning upon through the Glaxo to us, but for the sake of one submission, one word used by this court saying that when there is a statutory right, you have to utilize it in that manner. So my answer to that, my lord, as far as the 85(3)(a) is concerned, this is a provision as a policy from the legislature saying that the appellate tribunal, who will condone? It's a power to the appellate tribunal to condone or not to condone on a sufficient cause, that too of 2 or 3 plus 1. But so far as my lord is concerned, this itself by ipso facto is not impinging, and therefore 246 is not impinging 226. Absolutely, your lordships is beyond the pales of 246. I mean, we don't need to even get into that. It is basic structure and all, and therefore it is not, because it is not even talking about it. We need not have to read against us by not reading a provision against us. So this 85(3)(a), when it is the second level, this is the second stage. The first stage is the assessment. The second is once the assessment order is passed, then it needs to be challenged. Now, what is the policy? In the first round of assessment, the state, through a policy as part of this legislation and a procedure rather, is prescribing the manner in which the state will claim a right which does not exist. State, for the first time, like a Department of Income Tax or the GST or the Commercial Tax Department, they are authorized by this legislation to undertake a procedure to carry out an assessment to unearth a property which the state is entitled to through a charging section of that particular taxing law. So when that happens, because the moment there is an event, and all the charging sections are is event centric. And whether you demand it or not, statute operates on its own by operation of law through the trigger of that action.
True.
The moment that happens, it remains in ambulatory state. The state unearths its property, which is with me as an assessor.
True.
So the moment that assessment exercise is undertaken, and then you go to the assessment order stage, for the first time, the crystallization of the property of property right of the state comes in. Now, then somebody who is getting deprived of that particular property because of the claim of the statutory authority through an assessment order, now he will have to challenge that.
True.
So when he will challenge that, he will challenge through the procedure. Because for the first time, that right which is crystallized and accrued in favor of, rather not accrued, it crystallized in favor of the state. State is a litigant in there. So my submission, now my submission is this. Whether this appeal provision under the taxing legislation, prescribing this provision, which I call it as a procedure, which perhaps the other side may call it as a substantive right, that a right to appeal. This is a dispute between two litigants. Me is one assessee and the state is another litigant. State's one agency, instrumentality, that is the statutory authority, is carrying out the exercise of assessment and then crystallizing it. So me as one of the litigant is the state is also the other litigant.
True.
So therefore, can the same state say that this procedure of appeal is a substantive right to you, even though my right of redressal is flowing from Constitution?
It is a too far-fetched concept which you really want to.
I'll also show how, because this aspect is not taken care of till date, it is creating the jurisprudential disturbance. I'll show that as I move ahead. And this has not been taken note of. That's why I say that it remains res integra as if yet. And the consequences of this status has a far-reaching consequences. For example, today, I would have taken not more than 10 minutes to explain to my lords on the merit. But for the technicality, we get into the constitutions and the constitutional elements, beginning from my lords, your lordships, your Wadhwani, to right up to my lords, today your El Chandra and whatnot. Look at the amount of the time getting consumed. If at all there is a erroneous presumption, the jurisprudential element and scale is existing in the jurisprudence laws. It has a lot of perennial consequences across. And it has this, that's the reason why I say that it is to be read that a two litigant disputing with each other about a property, who owns it? And my right of redressal is not a charity. My right of redressal is not a charity from the legislature, but it is my natural right and it flows through the Constitution. And that is why your Lordship's judicial review is part of the basic structure which 246 can't impinge. That's the test, fellows. That just because, yes, I will approach through appeal to an appellate authority, should it be treated as a right given to me by one litigant again to the other? And look at this, one of the other provisions I'll show. Whereas given to assessee is only...
Then what will happen? Then who will be discharging the legislative function? If you talk about it is a litigation-centric manner, then who will... Because the government will always be a litigant at one way or another. Then there will be a separate organ so far as the legislative parts is concerned.
I'll answer that.
So it is because it's really a segregation. May I use in a very common and truncated manner is either segregation or a compartmentalization of a different personalities of a thing or a personalities of a man.
Right. Please.
So the government also discharges the different functions.
Right.
It's not only the legislative powers which is given. Some kind of an administrative powers is also given. There is another power how to run the government, to take out the policies. There are different ways of functioning.
No problem.
So legislative is one of the facet thereof, that they exercises. Maybe a litigant, but so far as the legislative is concerned, it is something different which they exercise.
Right, wrong, bad, ugly. A design of governance is design of the governance. I have no problem with that. My point is, what I am submitting is this before your lordship says, you don't interfere in the judicial review function of the Reed Court, Constitutional Court, where I am.
They cannot. That L. Chandra Kumar is very clear on that.
Correct.
Once you impinge upon any in the domain of that particular the constitutional powers of the writ court, definitely the court says you can't. Being a basic structure emanating from the Keshwanan Bharti, now it's being this Coelho's judgment and many other that Supreme Court, the Constitution bench has come. So these are the principles. There is no doubt about it. Again, I'm saying that we are not concerned with the right to approach the writ court is a one which cannot be curtailed. But how the writ court should function.
That's right.
That's what is curtailed by Article 141.
When your lordship says functioning, exercising a judicial review, if your lordships will be told by the executive saying that, look here, you are frowning upon a substantive right, that I have a right.
No, it is not an executive who is saying. It is by virtue of Article 141 which we are bound. The difficulty arises there. It is by virtue of that clause or the article.
Then we will get into the what is ratio.
That is what the ratio descendi. I know those principles. It has to be read in the context and cannot be read in an isolation or in I would say the adjunct manner. Right. This cannot be done in this way. I am conscious of it. But once there is I would say, some kind of observations have come which really impedes the entertainability to some extent. What should the court do?
Paragraph 19 starts with those panoli.
So now we have to consider in that way that does it really, what you are saying is to some extent is true, that it does not really create an absolute embargo in entertaining.
Right.
To that, the word in a routine manner has to be given a more emphasis.
Okay.
And given a more meaning, or I would say meaningful meaning to those. I understand that. But only problem with this regard is when you go in a legislative way, when you go in a procedural aspect, when you say that they cannot put any hindrance into the constitutional court in exercising their power, which is the basic structure under Article 226 or 227, then in that event, they are within their competence to use it, whether the writ court should go beyond.
What I'm trying to tell you,
that is what is there.
What is my endeavor is that so far as the legislation is concerned, giving a timeline.
Definitely, no doubt about it.
Only humble submission, kindly consider this aspect.
Yes.
That just in the special legislations like taxing legislation, where the state is in a quest to unearth its property right, the provisions of appeal, first appeal or second appeal and all, they not in a sense is a charity to me.
No. Why you treat it in that fashion? It's not a charity.
Otherwise, kindly consider this aspect of this substantive right is given to you, take it or leave it. Because what some of the possible argument could be against me, that because this is a right given to you, take it or leave it. Therefore, the court, when exercises that power, the court would not, because he is given the right. If he is given the right, he is not exercised that right in that manner. Therefore, you cannot ask for a more right from the court. Because what the enforcement of your lordships, I'm not asking for the enforcement of 85(3)(a). I'm not asking for that. I'm not asking that as a statutory right enforcement. I'm asking about redressal of grievances for a reason of a delay which your lordships is competent to adjudicate. So to say or to defend or to refuse or interfere in the administration of justice by claiming that it is a right given to you by the state, take it or leave it. That is why I brought that distinction between the largesse. Largesse is always linked to the condition. You take it or leave it. But when you are in the quest of unearthing your property with respect to another litigant, you can't say that if he has not come for a ABCD good reason. Suppose I died. My son took 3 months or 4 months to come. That is where lordships will exercise that. Of course, the statutory appellate tribunal will not be able to exercise that power because he is the creator of the statute. He will not be reach the statute. But when it comes to exercise of the jurisdiction of a 226, and to say that how your lordships will entertain that and adjudicate it as an additional condition, that because there is a limitation and you have come after that, he could not have gone there. So you also will. So what's the yardstick? Glaxo is not giving any yardstick. With due respect, Glaxo is at all not even giving. That's why I've read it. There are two components. First component and second.
Let us see on that score. How far it really.
Now, please kindly read the Glaxo again.
No. We have already gone.
All right. Now, my lords,
no difficulty.
Then your lordships may see this. If your lordship will see the paragraph 2, and I will not repeat, I will only say that para 19 observation in the facts of the case with respect to the para 1 question frame.
True.
And then despite the fact that the entire half of the entire judgment from para 2 to 13 is on the facts and the delay, and then 23 the detailed discussion and the delay. May I read it for a moment, the 23 paragraph for your lordship's consideration, how the court has gone into detail about 23 paragraph. Yes, 23. The same paragraph again for the kind consideration also you'll also see that.
That is the intention of the Honorable Supreme Court. That is the intention, and that is the finding, your lordship. Why Honorable Supreme Court's intent?
You will get lot of queries. Don't worry about it. Let him finish.
So, in other words, the fact that the High Court has
complacent from our interaction. Don't
No,
worry.
answer.
You'll face a lot of queries.
No, the fact that the High Court has a wide power doesn't mean that it would issue a writ, which may be inconsistent with the legislative intent regarding the dispensation explicitly prescribed under Section 31. That would render the legislative scheme and intention behind the stated provision odious. Now, that is exactly what my entire concern. That what is the legislative intent and what is the legislative scheme? The legislative scheme, according to my humble submission, is one part, and second is whether your lordships will have the jurisdiction to decide the condonation or not.
So from the line of judgments, it says that the court should not issue a mandamus upon the authorities to act either in derogation with law or in violation thereof. That were the principles which was really in a more succinct manner. This has been.
And more so, they were actually lamenting the placitum G regarding the ONGC because there are 3 judgments.
That's the interpretation. If the court has accepted the ratio of a particular case, maybe or in a different concept, and says that I find that this ratio applies here, as a High Court, by virtue of Article 141, can we say that this observation of the Supreme Court is perverse or this is not correct?
We don't need to say that. We don't need to enter into that.
It is binding on us.
Correct.
So we cannot take a dissenting view.
Absolutely.
Or a view which is which runs counter to.
Please understand the facts of this case. It started below the paragraph number 14 onwards to 19. It is on the discussion on 142.
I understand.
And then the judge is, the Honorable Court is saying, because in that case they did not exercise the 142 on the similar ground. No, if your Lordship will see. But this last two paragraph, the last two sentence of the paragraph 19 is in the conspectus. Last two sentences of para 19 is in the conspectus of the discussion on ONGC with the article 142. Because in there, they say that I cannot even condone 1 day also by being a statutory authority, and you can't ask me to exercise 142 and 142. These are the language of 142 in that judgment. What it says, the 142 will not be at the cost of the legislation and legislative intent and scheme. It is borrowed from them, quote unquote. Here the court is, therefore the third, the placitum G is talking about the ONGC. We will be frowning upon a 3-judge bench because we are a 2-judge bench. Then if your Lordship will see the 23, the entire discussion on the delay and condonation. Now I want your Lordships may just have a look at it for a moment. Para 23. Arguendo, reverting to the factual metrics of the present case, it is noticed that the respondent had asserted that it was not aware about the passing of the assessment order dated 21st of June 2017, although it is submitted that the same was served on the authorized representative of the respondent on 22nd June 2017. The date on which the respondent became aware about the order is not expressly stated earlier in the application for condonation delay filed before the appellate authority. The affidavit filed in support of the said application, or for that matter, in the memo of writ petition. On the other hand, it is seen that the amount equivalent to 12.5% of the tax amount came to be deposited on 12th of September 2017 for and on behalf of the respondent without filing an appeal and without any demur after the expiry of the statutory period of 60 days prescribed under section 31. Not only that, the respondent filed their formal application under Rule 60 on 8th of May 2018 and pursued the same in the appeal, which was rejected in 17th of August 2018. Furthermore, the appeal in question against the assessment order came to be filed only on 24th of September 2018 without disclosing the date on which the respondent in fact became aware about the existence of the assessment order 21st of June 2017. On the other hand, in the affidavit of Mr. Siddhar Raut, site director of the respondent company, filed in support of the application of condonation delay, it is stated that the company became aware about the irregularities committed by its erring official in the month of July 2018, which presupposes that the respondent must have become aware about the assessment order at least in July 2018. In the same affidavit, it is asserted that the respondent company was not aware about the assessment order as it was not brought to its notice by the employee concerned due to his negligence. The respondent in the writ petition has averred that the appeal was rejected by the appellate authority on the ground that it had no power to condone the delay beyond 30 days, when in fact the order examines the cause set out by the respondent and concludes that the same was substantiated by the respondent. The finding has not been examined by the High Court in the impugned judgment and order at all. But the High Court was more impressed by the fact that the respondent was in a position to offer some explanation about the discrepancies in respect of the volume of the turnover, that is on merit, and that the respondent had already deposited 12.5% of the additional amount in terms of the previous order. That reason can have a no bearing on the justification for non-filing of the appeal within the statutory period. Now the court is dealing with the justification of the Supreme Court. Notably, the respondent had relied on the affidavit on the site manager and no affidavit of the employee concerned, or at least the other employee who was associated with the erring employee during the relevant period has been filed in support of the stand taken in the application for condonable delay. Pertinently, no finding has been recorded by the High Court and that it was a case of a violation of principle of natural justice. That means they say that no finding is recorded by the High Court that it was a case of violation of principle of justice on non-compliance of the statutory requirement in any manner. Now, I would like to pause for a moment. All these reasonings you also saw in the discussion in para 23 is all indicating that the High Court did not committed an error not examining the condonation delay. So, if the 19 is talking about a binding precedent of law, the court would not be doing the 23 what? It is rather asking the High Court should have done that. Then, Lords, be that as it may be, since the statutory period specified for filing the appeal has expired long back in August 2017 itself, and the appeal came to be filed by the respondent only on 24th of September 2018, about 1.5 years, without substantiating the plea about inability to file the appeal within the time, no indulgence could be shown to the respondent at all. Now, what the 19 in the background of the question at 1 with a 2 to 13 paragraph full of facts and delay, and then examining those delays in para 23. In the background of our ONGC, which is with respect to 142 exercise of power, which the court in that judgment 2017 stated that even with 142 cannot be exercised, because that in ONGC, they were actually telling to the court that since you have already condoned, you still have a power of 142. If the other side is raising an objection, then also you can negate it. But the court said that, sorry, even if the condonation has happened, because this is a threshold issue, it can be raised, that is how the condonation order was withdrawn, and the consequence effect is that is ONGC, that they did not exercise 142, while they were exercising statutory appellate function, not the constitutional function, as opposed to this paragraph 23 read with 19. My lord, by no means, none of these phrases, neither the last 4 lines, is talking about any precedence of the nature which the court in para 23 itself is negating. Why would we read a provision or a language of a judgment against us if the court itself is not reading it against itself? And therefore, the res integra, the ratio decidendi or a precedence, Iqbal, Muhammad Iqbal, I have given a tabular presentation in that, in my alternative remedy written note. Iqbal Eliashi, which it has stated below that this is also state of Orissa versus Muhammad Eliasi. This is at base number 11 of my written note. What it says, I don't want to get into that, but this is not a case of a ratio decidendi, so I'm not even explaining that. I'm only saying that what the proposition there the Honorable Supreme Court has stated. A decision is a precedent on its own fact. Each case presents its own features. It is not everything said by a judge while giving judgment that constitutes a precedent. The only thing in a judge's decision Binding a party is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from ratio disability. I would like to pause for a moment, Manoj. What the court has decided is at paragraph 23. The court is not saying what it has stated in the last 3 lines of the paragraph 19, which I say, Manoj, this is nothing but an paragraph 19, last 3-4 lines, which is I say respectfully submit, Manoj, this is nothing but an extract from the ONGC. Then, Manoj, according to well-settled theory of precedence, every decision contains 3 basic postulates. Findings of material fact, direct and inferential. Then an inferential finding of fact is the inference which a judge draws from direct or perceptible facts. Then number 2, statements of principles of law applicable to legal problems disclosed by the facts. And judgment based on the combined effect of above. A decision is an authority for which it actually decides. Now, what it decides? It decides also on the delay issue. What is of essence in a decision is its ratio, and not every observation found therein, nor what logically flows. Now, it is a judgment on section 31 of the Andhra Pradesh VAT Act. Are we going to say that the last 4 lines of para 19, we need to bring a logical effect of this 4-line language, qua the section 85 subsection 3A or section 107 of the GST Act? Maybe the language is absolutely identical. Can we have an inference? A judgment on ABCD ground is a good law for ABCD, for an EFGH. And the facts are different. The law is different. Then to apply a judgment, we get into a mini trial of that judgment, which I think we have done it. For example, Mother, so far as the Glaxo is concerned, we have already done a mini trial.
No. That is a different aspect.
So therefore, a
little difference in fact or an additional fact may invite some other conclusions.
Correct.
That may also come. There is no difficulty.
That's right. So now, then I may not read it. Enunciation of reason, that's important. No? Enunciation of the reason or principle on which a question before a court has been decided is alone binding as it. Now here the question is said whether the writ court can be entertained only on the ground of the delay. My writ petition is not only on the ground of the delay. My writ petition is there is a violation of statute. Section 93 violation happened. My reason is that there is a principle of natural violation and justice's violations. My reason is also there is a non-application of my non-consideration. These are all statutory violations. Because section 93 is an exemption given to me. You have not even dealt with it. You are committing a violence to a statute, but you are not. So who will decide it? Obviously, a court will decide. And I have invoked the 226. A case is a precedent and binding for what it explicitly decides. And no more. Words used by the judges in their judgments are not to be read as if they are words in an act of parliament.
They cannot be read as a statute.
Right? Now this is a judgment, a last 4 lines of a para 19, borrowed from another judgment of 2017. The factual matrix is different, the propositions are different, questions of law are different. Now, applied in this case, despite 23 comes in, the court says that, oh, you should have decided the delay issue, but you have not decided at all. That's the cavalier element, which in fact the 5th line from the bottom of para 19 says. So, my respectful submission, Mala, when therefore I began by saying that it is not a maintainable, it is entertainability. How your lordships will entertain? If your lordship will entertain, then what? Parameter of section 85A, limitation. Now, limitation, according to my submission, my lord, is not a charity from the state so far as when your lordship is exercising the jurisdiction for a judicial review of a delay and condonation. My lord will then see that provision That's section 85(3)(a). Now, when my lord will see that, my lord will only see the period is given there. I could not. This is a fact. Now, of course, that itself will not drive your lordship's judicial review function. And then to say that if your lordship will exercise, in any case, the moment your lordship is exercising the judicial review function and entering into a justiciability, then obviously, my lord, so your lordship is then frowning upon the, if at all somebody says that it's a scheme, it's an intent of the legislature. What intent of the legislature? Are we then reading against ourselves by saying that this is a right given to you, you did not exercise that right? I'm not coming, I don't treat that as a right to me. Therefore, I have not come to this court for enforcement of that right to me. I'm not saying that. I'm saying there is a delay happened for reasons beyond my control. ABCD, my facts. My lord is having the jurisdiction. My lord will decide that. And then, my lord, your lordship, then I'll take you through, my lord, 1, 2 more judgments, then I'll be done. One judgment is here, my lord. This is Rikhav Jain. You have it? Look, I'm reading the relevant portions. I'm not having it. I'll give you a copy of that. Okay. It says, this is a 2025 Justice Srikanth Datta judgment of the Honorable Supreme Court, a 2-judge bench judgment. This is also, here in this case, this is under the Customs Act, where under the Customs Act 1962,
Yes.
where the High Court was exercising parallel jurisdiction both under the statute as well as the indeed. The High Court had a double jurisdiction. So what in this case has happened? The party did not go to the High Court. They went to the High Court in appeal against the CGAT order. They did, instead of challenging through section 130 appellate route like ONGC, they actually went through the 226. So what the court is saying here, that at the yes, so it's saying. No, not this one. That's what you need.
You just give me a citation that's will take care of that.
Yes.
Just give us a citation.
Citation,
Rikhav Jain.
Rikhav Jain and yes, Unit of India. What it says, Balot, that it has also discussed the Titagarh paper mill and the Godrej Sara. What it says that availability of an alternative remedy does not oust the jurisdiction of a report.
True.
It was also explained how entertainability of a repetition and maintainability are two different concepts.
You just give me a citation. If it is a neutral citation, give the citation and.
Yes, this is.
That is 2025, my lord.
From the, yes, 2025 INSC.
2025 INSC 133.
2025 INSC
1337, my lords.
1337.
Yes, definitely. We'll take care of it.
And then Wadhwani. The Wadhwani that is of 1961 is a 5-year constitution bench.
Yes.
What it says that
what is the citation?
AIR 1961.
AIR 1961.
SC 1506.
1506.
Yeah.
Yes.
So it says, my lords, that sound exercise of the discretion is property. Even if alternative remedy is over.
True.
And that is this 5-judge constitutional bench judgment of 1961. This is also C. Customs Act, where in that case also, they went to the High Court, where the High Court was also the jurisdiction under the statute. It's about 1878 C. Customs Act, where instead of going to the central government, which is a regional alternative forum, they straight away went to the High Court. So what the court stated in that law is a 5-judge constitutional bench that if a fair and judicious exercise of the discretion is the test. So even if the limitation is over, because Limitation Act is not applicable to us. And these are the two judgments is squarely falling on this.
Yes, we'll take care. Yes. Thank you.
And there's a second case, the item number 29. So far as that item, that is 29 is concerned, there is about 10 days. Unlike this, there is no delay.
I understand.
Yes.
It's a 1-day delay. That is one factor. Let us see if we can, that it does not undermine the powers of the writ court under Article 226. Then it's immaterial that the length of delay is immaterial in that regard.
Right.
If it is 10 days or 100 days, it all is a one thing.
And so far as well, if your lordships is also not guided by the provisions of the Limitation Act, but 4 to 24, well, section 4.
Oh, that is under section 29(2). I know 4 to 24. That will.
In our case, when you are sending me off from the door by saying that means you are not invoked the 14, because even the appellate tribunal also is entitled to exercise 4 to 5 can be obliterated, or 5 is substituted so far as the proviso is concerned. 5, section 5. But 4 to 25 still exists.
Let us see. Yes.
But my case is different. Because I have challenged this, because I have not had principle of nationalism has not been given to me. So there is a violation of Article 14 of the Constitution of India. And the other part is, I have paid the tax in 2016-17 financial year. And the challenge as well as the receipts, bank statements, I have already annexed. So here it is only 6 lakh rupees. And I have not anticipated that you'll also get it from the order that is page 13 first. It's clear that I find, in spite of issuing show cause notice, the notice has not replied to the notice. Also, he has not attended the personal hearings granted by the adjudicating authority. So this is sheer violation of natural justice. So that part will be considered. It's not this. They have participated in the proceedings.
Yes. Any member of the bar who is there?
I'm for the department, my lords.
No, not department. Before the department.
Is there a lordship of similar massive lordship? Mr. Sami was supposed to argue.
No, I just invited the members of the bar because the department has taken this view. We will hear him. So any member of the bar who can lighten on this aspect. Yes, then I take it that on that score, let us hear the department.
Next step, can continue. A short date.
No. Yes.
My lords,
Yes.
Lordship's attention to the Glaxo judgment once again, my lords. Para 1, my lords has seen it umpteen times now. My lords may see the question formulated by the court for once again, my lords.
Oh, that he has said. There is no
question that is formulated and the answer provided. That from that, my lords.
That is his main endeavor is that even if entertainability, the court cannot put any restrictions because it all depends upon a fact to a particular given case to another case. Even if there is a rampant violation apparent on the face of the record of the natural justice, does it really take away the right of an individual or a citizen?
My lords, when there is a complete violation of natural justice, this court's doors can never be shut to the petitioners, to the parties.
But
This is not a case of violation of natural.
if the observation in paragraph 19 is to be considered in that perspective, then it really creates I would say that hinders the
My lords, for that reason, my lords,
sustainability by the High Court.
I bow down to what lords.
Is it a ratio of a law declared by the Supreme Court to bind by virtue of Article 141?
My lords, as far as my lords, para 19 is concerned, lordships, much emphasis was laid on the phrase ordinary course. In ordinary course, this was not a case of ordinary course.
That is a different. That means even in a given situation, your argument is that there cannot be any absolute fetter put on the Constitutional Court entertaining the writ petitions concerning that particular assessment order or a decision of the authority without exhausting the statutory remedy within the period of limitation.
Grateful, my lords. A party, my lords, who has not been given an opportunity of hearing.
So I take it there is no fetter.
There is no fetter, my lords.
Correct.
In a case,
then I take it.
I cannot argue this proposition, my lords, that there is an absolute fetter on lordship's power. As far as present case is concerned,
then the merit is the another factor.
But as far as maintainability is concerned,
let us hear Mr. Mishro if he has some.
My lords, I have prepared, my lords, as far as
other impression about this judgment.
Has passed some judgments. There is a judgment of your lordships in Vikas Panigrahi, my lords. Lordships of Glaxo judgment. There are recent judgments, my lords, have followed Glaxo.
Mr. Mishro is taking all the credit for that judgment. So let it.
No, not only that judgment, your lordship.
Is it argued?
There are 14 judgments, 14 high courts.
Yes.
Your lordship, even though out of the court I don't support this judgment, but your lordship, officially I have to support this judgment. Why, your lordship? Why, your lordship? The logic, simple logic, your lordship, paragraph 19. The finding line, the last line of the paragraph 19. Paragraph 19, the logic of Honorable Supreme Court is that if the delay, the statute says 100-01, 100-07, your lordship, 100-07-1, 3 months, 100-07-4, 1 month. So that 1 month power statute, legislature has given that 1 month power to the statutory authority to condone the delay. And beyond that, there cannot be any condonation of the delay. Your lordship, so far as the entertainability of the writ petition, your lordship, in so far as the other cases, in spite of the alternative made, your lordship, there is absolutely no bar. Why particularly on this subject, your lordship, where the outer limit? And your lordship can find out from the three judgment, HON'BLE India, Singh Enterprises, and even in many statutes, your lordship, NCLT, your lordship, by NCLT, your lordship, company law, your lordship, arbitration, your lordship, where there is outer limit is there. So there it is a bar. Why, your lordship? Because the only that is the provision will be, if the delay will be condoned, the provision will be. Nobody in the intention of Honorable Supreme Court is that even our particular language is that sleeping. If you slept, that cannot be an excuse. Your lordship, you sleep, and after that, after completion of the limitation period. So because in the appeal, if within the limitation period appeal could have been filed, there is statutory deposit, pre-deposit, many things are there. Your lordship, because as per the statute, nothing is here, your lordship. So, for that reason, the particular restriction Honorable Supreme Court has imposed in this judgment, your lordship, not imposed, your lordship, directed that, and the particular language before and after, and what is the intention that paragraph 19 part has been said. Now, your lordship, before your lordship, this particular issue I have argued, and before that, your lordship, before the coordinate bench, your lordship, long before your lordship, I have argued this matter. And this Honorable Court, the coordinate bench, has accepted that judgment. And basing on that judgment, Honorable Rajasthan High Court has accepted that judgment, and both Honorable Supreme Court judgment and Honorable Rajasthan High Court judgment in case of Malik Khan, I have argued before this Honorable court before the coordinate bench, and coordinate bench has accepted that judgment. And after acceptance of coordinate bench judgment, I have argued this case before your lordship. And your lordship has recognized all the judgment. This this coordinate bench judgment in Lockheed Construction and Rajasthan High Court judgment in Malik Khan. So let's make kindly turn to directly.
With kind permission, all the judgments I've read it. They are all in my favor.
No problem.
Yeah, it's all in our favor. It's all dealing on the delay.
Your lordship. Paragraph 6.5, your lordship, page 15. Heavy reliance is placed by Mr. Sunil Mishra, while standing counsel in the case of Lakshmi Construction and versus State of Orissa, State Tax Officer, City GST Circle, Barbi. By judgment dated so wherein this court has referred to the case of Assistant Commissioner CPLT Kakinada, versus GlaxoSmithKline and the decision of Rajasthan High Court.
That is the what we really adumbrated, or we have reiterated what the law on this subject is. But ultimately, what was there that we also went into the merit whether there is a plausible explanation given for the purpose of a delay, and we found that there is no explanation whatsoever which would come within the purview of the sufficient explanation. And we said that we do not want to entertain, but we have never decided anything, because we also perceive that the service is also there. What is the mode of the service which is also provided, and it will be deemed that the service is there. So it's not a conclusive the decision on the exercise of power by the writ court in entertaining.
Your lordship stated that sustained perception which assists this court to arrive at the conclusion that the order, if the notice and order is uploaded in the portal, and that will solve.
So that is a different aspect. That means we exercise our power under Article 226 in such situations.
The state considered service and the repetition is not maintainable. Being beyond the tolerable period.
That is what we found on merit, that this maintainability is because factually we did not. Their contention was that it was never served. The notice was not given. We held that no notice has been given.
That one part. Two parts are there. That one part. The second part is while beyond the condonable period.
That's yes. Actually. We have.
Now the lordship may kindly look into the judgment of the coordinate bench on the same facts, your lordship. Coordinate bench has also said that that once the order has been served.
Oh, that is a different, Mr. Mishra. We are not so deep into the aspect. We will consider the merit of each case, and if we find that if they are saying that the notice has not been served, and it appears from the record that the notice is served, they will be defeated. There is no question. Question is again on a very broader aspect. We were thinking 226. Your counterpart has agreed. No, there is no absolute bar or embargo. I wanted your view.
Your lordship, my view, if your lordship please close down the PC.
No, I understand. I understand. We'll consider every case on its own merit. Don't worry.
My submission. Once the order has been served.
Oh, true.
So
if it is served, it is served. There is no difficulty.
So from that day, the limitation is countable. And if the writ petition has been filed within that limitation, statutory limitation period, then it is entertainable. If not filed, then it is not.
Let us see.
And I will assist your lordship from judgment of Honorable Supreme Court 5th bench, your lordship was proposed.
What?
In favor of the petitioner, your lordship.
Yes.
Your lordship, the dealers should not be remedial. In that judgment also, Honorable Supreme Court has interfered in that matter And by referring that judgment, the
Give.
coordinate bench has allowed that
Give.
Your Lordship pass.
If we have a larger quorum judgments, then there is no impediment on our part to go it.
Your Lordship, I'm just.
This is give. So I think other person will argue.
Well, in both the matters, my lords, that compilation of given Wadhwani, 1961 Supreme Court.
So it has not come today, so I have given a.
Let us first decide the major aspect of it, and then definitely no difficulty.
Lords, the compilation, my lords, of Wadhwani, 1961 Supreme Court.
Yes, we'll consider. Wadhwani is also there.
My lords, Wadhwani, my lords, they say that party who has not come to the court within the time.
That we'll see to it. Don't worry.
Let's say the department, since the department has considered that your lordship has the power of entertainability.
No, it's not a concession. It's a never treat it as a concession on fact. This is really what he very fairly understood. But he says that we cannot whittle down the applicability of that clause also in view of the facts which are present in the cases.
That's one.
So it's not a concession. Don't treat it as
Here in this case,
It will not be.
he has approached after the time period, therefore he's.
Oh, that is, I understood. I understood.
We are not considering also, we are against your your payment of.
Yes,
Your Lordship. Because you cannot support.
Let him have the luxury of inference.
They are always a formidable opponent to you. There is no difficulty.
Malad, in that fourth written note, I have only read only the Malad bin Muhammad, Iqbal Muhammad. I have only read only one judgment, that is on the ratio decidency. That your lordships wanted me to find out the judgments on the precedents, the beta dicta, and of course the stay decisis. What I have done, I consciously did not get into the entire thing. Malad, we take another 10 odd minutes, which I wanted to avoid. Reason being, Malad, we have perhaps, Malad, that's my understanding, I may be wrong. I got the sense that we have gone beyond the main door. Now your lordships can decide the inevitability. Therefore, it is no more within the realm of
the coordinate bench, Honorable Justice Horizon Singhal.
Please give that judgment. We'll
In that
consider. We'll consider. We'll depend upon this.
Well, let him serve a copy of the notice of submission. I'll also respond to that, my lords, if your lordship speaks next.
Let the matter be listed.
That is the single way judgment.
Substantial argument has already advanced by the respective counsels. And
My part of the argument, Your Lordship.
please submit.
Your Lordship, my part of the argument may be considered.
It is open to all the appearing counsels to file their notes of submissions.
Argument may kindly be considered because tomorrow, if this can be allowed, then tomorrow, Your Lordship, nobody will bother to go to the appeal because it will be easier than appeal, Your Lordship.
And beneficial for the members of the bar here. Yes. Yes.